sole respondent, my lordship. In this case, we have engaged a senior counsel. So today we are going to file a Ukalatnama, my lordship. We have taken the consent of the others.
Miss, what's her name?
Arvind.
R. Begum, learned counsel for the petitioner.
Respondent, my lordship.
Learned counsel for the respondent who prays for an adjournment. She submits that she has informed learned counsel for the petitioner regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed.
Give a date in the 28th July, my lordship.
28 July, 29 July, right, 28 July.
Please, Your Lordship. I beg to mention
Obliged.
item number 10, my lord. I have taken the consent.
Item number?
10, consent of the others that I have taken, my lord. Today I have some difficulties, my lord. They fix it any date on next week, my lord. Item 10.
Heard Mr.
May
M.A.I. Hussain, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed regarding his prayer for adjournment to the learned counsel for the respondent, who does not have any objection. Hence, prayer is allowed. Let this matter be listed. 17 June. The interim order shall continue till next.
Hello,
Also, item 15, already part heard before Honorable Pranjal Dasmi.
Okay.
Order it dated 19/5 reflects. It's a part heard.
Heard Mr. M. Kolita. You are for
Respondent.
item number?
Item 15, 1/5. Joyশ্রী Rabha.
But he, Joshi Rabha. Okay. Who, you have informed the other side?
So it's already part happened.
Who's
They know it very well.
learned counsel for the respondent submits that this matter has been kept parted by another coordinate bench of this court. Hence, is praised for listing this matter before appropriate court. Stop registry to verify and list the matter before appropriate court.
So
My lord, I beg to mention for item number 19, my lord. My lord, may kindly fix this matter on 28 August, my lord.
Why?
My lord, the problem is that, my lord, here, this case is of 2011, my lord. And in this long duration, my lord, now the petitioner, I don't know where she is. I have to find her out. That's why, my lord, unless I trace her out.
What is the matter?
Regarding maintenance, my lord.
You are sure you will find her out before 28th August?
I'm doing my best, my lord, because she stays in Borpeta or like that, my lord. But
Heard Miss, what is her name?
SD Chaudhary, my lord.
Heard Miss S.D. Chaudhary, learned counsel for the petitioner. You have informed the other side.
There is no other side, my lord. The thing is that, my lord, here earlier it was Sanjay Medhi. Now he is CGSC, my lord. So for representing the respondent, the advocates are there. M. Burman is also there. She is no notary. So I have told them earlier also, but now they are not taking interest, my lord. Problem is there, my lord. That's why.
Submits that she has lost contact with the petitioner and prays for some time for taking necessary instructions in this case before she makes her submissions. The prayer is allowed. Let this matter be listed
28 August.
on 28th August, 27th August.
Obliged, my lord. Hello.
May I please, Lordship? Lordship, I beg to mention item number 23, Lordship. And I'm on behalf of my senior, Mr. A. Sadhguru, Lordship. Lordship, kindly adjourn this to this matter.
You have informed the petitioner's counsel. You have informed. Heard Miss, what's your name?
Videka.
Heard Miss B. Deka appearing on behalf of Mr. A. Sattar, learned counsel for the respondent who prays for an adjournment. She submits that she has informed the learned counsel for the petitioner regarding her prayer for adjournment. Hence, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after
Weeks, Lordship.
give a fixed date on 30th of July.
Item number 2. In this matter, Lordship, Mr. R. Kalita is engaged. Lordship may not like to take up the matter. Learned friend for the respondent is present.
Item number 2, list this matter before any other bench without me, within bracket my name,
It's a date, either on 23rd or 24th of June.
on 24th of June.
Obvious.
Lordship, I'd like to mention item 8 for adjournment, Lordship. The conducting counsel K. Borwa has some personal difficulties, Lordship.
You have informed the other side, respondent.
As per instruction, or from senior.
Other side has been intimated. Informed or not?
Yes, Lordship.
Okay. Heard Miss, what is your name?
Chip.
Heard Miss M. Bhuya, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty. She submits that she has informed the learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Stop. Hence, the prayer is allowed. Let this matter be listed 15th of July.
May it please your Lordship. Lordship, I beg to mention item number 5 and 6 on behalf of the petitioners. I have taken consent from the learned counsel for the respondents, Mr. Shom. He has conceded, my lord. The matter may be fixed after a week, my lord. Interims may be continued. But my learned friend is here only.
Heard Mr. D. K. Buddha, learned counsel for the petitioner. Also heard Mr. A. R. Shom, learned counsel, the learned counsel for the respondent number 2. Learned counsel for the petitioner seeks an adjournment on the ground of personal difficulty. The learned counsel for respondent does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed 17th of July.
Deeply obliged.
And please, your Lordship. Lordship, praying for listing of a matter in admission.
What matter?
Criminal petition, Lordship.
Senior court is there. Court number 8. Go to court number 8.
5 and 6, the interims.
The interim order in 5 and 6 shall continue till next day.
Yesterday one matter, last hearing matter, my lord, was left over, my lord. There was the interim prayer, my lord, it was not been continued, my lord. Therefore, I am saying, my lord, this matter will be listed in the next week, my lord.
When is the listing?
Yesterday it was listed, but it was left over before your lordship.
Leftover, you have to mention before senior court if no order has been passed.
Obliged.
This is motion be item 1.
May it please your Lordship. Second, the petition Lordship, before the petitioner 1 for Lordship, and the petitioner, so far the petition 5 is concerned, this is the third round division Lordship by the petitioner 5. But we have rejected the earlier petition Lordship, find the order at the page 57, starts from 57 Lordship.
Page number?
57 starts from.
Putul, microphone check karo. Yes. Page number 50?
From 57 Lord.
Yes.
Relevant person Lordship, it start 60 Lordship. Paragraph 10 Lordship. So he further submits the considering the incriminating materials against the present petition, they may not be allowed to go on bail Lordship before exemption the above mentioned 4 witnesses, as they hail from same locality and there is a every possibility that if they are released, they may try to influence the witness. Next lordship, I'll have at the para 13 lordship. On perusal of your records, it appears that there are indicative materials against the present petitioner and they.
Which para you are reading?
Lordship 13,
Para 13.
lordship, page 61. She got it, lordship.
Yes.
On perusal of records, it appears that there are incriminating material against the present petitioners and they have been specifically implicated by at least two witnesses who are shown as eyewitnesses in the search sheet. Out of those two witnesses, one namely Kanak Pegu has already been examined as an eyewitness, lordship. Next, lordship, kindly have a look at page para 15, lordship. Considering the submissions, the said witnesses, which was recorded under section 180 of VNSS 2020, as well as considering the submissions made by the learned additional public prosecutor, this court is of the considered opinion that in view of the infinite evidence of the said eyewitness against the above named petitioners, it may not be proper to release the petitioners at this stage before examination of the said eyewitness, namely Bhogaputam.
Yes.
Said Bhogaputam has already been examined, lordship.
Where is the
Lordship will find the. The page, lordship. 74.
thereafter you approach the trial court?
Before the trial court.
Where is the rejection order?
Lordship will find it at page 84, lordship. Relevant person at page 85. The evidence of the witnesses are a very incriminatory. Considering all this court is of the view that this is not a case where bail can be granted to accuse on the paper, so and so and so and so. The present petitions, accordingly, the bail period is rejected. All the eyewitnesses have already been examined, lordship. There are two the eyewitnesses, lordship, both are already examined, lordship. There is no sense of the tempering the evidence, lordship. And the information has also been examined, lordship, by the learned trial court, lordship. Ajanta Kutu, she has also been examined, lordship.
Yes, Mr. Bush.
My lord, here, my lord, in this matter, alia when rejected, my lord, this is on my lord 8/4/2026, my lord, was pleased to reject the same matter. And my lord, there, my lord, arrest, my lord, that is, my lord, by the of my lord, custody warrants, because they surrendered, my lord.
Already appeared, lordship.
My lord, before my
Surrender
lord, there is the accused persons, my lord.
on the petitioner.
All the petitioner, it is in my lord,
Forward.
annexure 4, my lord, page 46, my lord. Page 46, my lord, order dated 12/11/2025, my lord. So that is there, my lord, then my lord, they were, my lord, custody warrant issued and my lord, they were, my lord, sent, my lord. So now, my lord, when my lord was pleased to reject the same, my lord produced the, my lord, the scanned TCR, my lord, thereafter only, my lord. Okay, my lord, it is in the motion.
Mr. B.K. Gogoi, learned counsel for the petitioners. Also heard Mr. K. Bush, learned additional public prosecutor. This application under section 183, 483 of BNSS 2023 has been filed by the petitioners, namely Shri Anil Pegu, number 1, number 2, Shri Hiren Kutum, Shri Falguni Pegu, Shri Utpal Pegu, and Shri Vikas Pegu, seeking bail in connection with Sessions case number T1-T113/2025, pending in the court of Learned Sessions Judge Themaji under section 61 within bracket 2/189 within bracket 2/103 within bracket 2 of BNS. the petitioners when were you arrested?
12/11, Lord, 25.
All.
No, Lord, 1 to 4,
And number 5,
6/8/2025.
the petitioner number 1 to 4 herein above were arrested on. No, you said you surrendered.
Sir,
Yes,
issuing the custody warrant, they sent to the judicial custody.
You surrendered all of them.
yes.
On the before surrender, Lordship, 51 is arrested by the IO, Lordship, on 6/8/2025.
Petitioner number 1 to 4 had surrendered before the court on 12/11/2025, and thereafter they were remanded to judicial custody, whereas petitioner number 5 was arrested on 6/8/2025. Learned Mr. B.K. Gogoi, the learned counsel for the petitioner, submits that no, before that, the gist of accusation in this case is quote para 4 and 5 from page 49. Stop. The learned counsel for the Mr. B.K. Gogoi, the learned counsel for the petitioners, submits that this is for the second time the petitioners have approached this court seeking bail. Stop. He submits that on earlier occasion their prayer for bail was rejected by this court by its order dated 8/4/2026, passed in bail application number 885/2026. He submits that the main reason for rejection of bail on last occasion by this court was that out of 2 eyewitnesses, only one was examined at that point of time, and the remaining eyewitness, namely Boga Kutum, was not examined at that point of time. The learned counsel for the petitioner further submits that this court also granted liberty to the petitioners to approach the trial court seeking bail after examination of the remaining eyewitness, namely Boga Kutum. Stop. He submits that accordingly the said eyewitness, he submits that the said eyewitness, namely Boga Kutum, was examined by the trial court as PW3 on 4/5/2026, and thereafter, in pursuant to the directions of this court, the petitioner approached the trial court seeking bail. However, the trial court, by its order dated 11/5/2026, passed in Sessions T1 case number 13/2025, rejected the prayer for bail. Mainly on the ground that incriminating materials are there against the present petitioner's staff. Learned counsel for the petition. How many witnesses are there total?
6/8.
Total, how many witnesses are there in
Total,
the charge? Learned counsel for the petitioner submits that the petitioners are ready to cooperate in the trial, and
9 witnesses, Lordship. The remaining
how many have been examined?
fifth.
5 have been examined. That there are total 9 witnesses, out of which only 5 have been examined. And how many accused persons are there? 8.
13.
Others are on bail. He also submits that apart from the present petitioners, the remaining accused persons are already on bail. Stop. On the other hand, learned additional public prosecutor fairly submits that this court, while rejecting the bail on the earlier occasion, had mentioned the reason for said rejection as non-examination of both the eyewitness. However, it appears that both the eyewitnesses have been examined. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Since the reason for the earlier rejection of bail application of the petitioners was mainly non-examination of the eyewitnesses at that point of time, so that there may not be any possibility of influencing the eyewitnesses. However, as the said eyewitnesses have been examined, no such possibility remains. Moreover, considering the submissions made by learned counsel for the petitioner that the petitioners are ready to cooperate in the trial, this court does not find any justification to keep them behind the bars during the remaining period of trial. Accordingly, the petitioners are allowed to go on bail. Accordingly, the above named petitioners are allowed to go on bail of rupees 30,000 each, with one surety of like amount, subject to the satisfaction of the trial court, that is, Learned Sessions Judge Demaji, with following conditions, trial conditions then.
Some stringent conditions may be there, madam. Otherwise, madam, if they might not even appear before the trial court, madam, it will be there, madam. Some conditions may be put, madam.
Yes, I will give trial conditions.
Right.
This bail application is accordingly disposed of.
Deeply obliged, Lordship.
Order item 14 and item 26.
Twenty-six. Yes, I am releasing it from part heard.
Edit. Yes. You've heard it at length. Now we are just seeking stay on the matter. Where the petition has also been tagged, the IA 1845
What is the I?
for stay of the execution.
Lordship, this is a sub judice matter, Your Lordship. Another IA 3955 is already pending
For stay?
for stay.
Then why have you?
And stay will be consequence of admission, Your Lordship. It has to be either
No, there is a reason.
39?
55.
39.
Five.
You verify if already one stay is pending by same petitioner.
There's a big reason for this. Number one, that we got this file from another council.
No, you have to verify the records.
Verify
If the
records.
petitioner has already filed, you have to withdraw one of the stay application. Two stay application cannot.
Pursue at the same time.
Yes.
3955, that IA 3955, because I got this printed out. But there is a big difference also. The execution case was not filed at that time. And then we went to the trial court, the executing court.
I'm not hearing. Two applications seeking same relief by the same petitioner cannot be considered. You have to take back one application.
So that is what we were trying to do it within the court hearing, actually. How to go about it? Because there seems to be some developments since then, quite a big development actually. And so we have brought on record those developments that has happened now. For example, the execution case was not filed. Now the execution case is filed, and the trial court is again and again repeatedly seeking, the execution court is seeking the appellant court's stay order for the execution. The party will be at.
No, why it is seeking?
So this is in annexer, the orders.
No, which stay application should the court consider?
184.
And what will happen to 3955?
3955 was filed by the previous councils.
No, we are not concerned with the council.
I absolutely understand, but there is a big development since then. So therefore.
No, Miss Saikia, you have to decide which interlocutory application you will pursue.
We are trying to pursue the interlocutory application that.
Then withdraw the earlier one. Take a decision.
I'll take a decision. I'll make a decision. As we come along, I'll make a decision. You court will just give me a few minutes just to brief.
No, I will not hear unless you take a decision which.
We'll go by this one, 1845.
And then withdraw this one.
Court will pass an order about it. The
We,
to withdraw this.
no, we cannot force you.
We are not being forced. It's just that, like
You
I said,
consult your client.
the instruction. of the client.
Instruction from the client, which one is to be pursued. Court will not hear two petition on same relief by the same petitioner. Counsels may be different.
We accept that. We accept that.
Ye-
So this is the one which is the late.
Because tomorrow the petitioner may engage another counsel and may file a third IA on the same petition, same matter.
That might happen, but this is the one with which we are.
Therefore, I am saying you take a decision
We
which
made a decision that we are going to pursue this one as we are speaking. And the matter that he took up, that there was a petition pending, that is 3955. We've taken a printout of this, and we will go by the latest one, because the latest one has all the developments that has happened till now. So we'll withdraw.
they are not pursuing this.
Not press for.
In 3955, heard Miss A. Saikya, learned counsel for the applicant. Also heard Mr. B. J. Mukherjee, learned counsel for the respondents. All respondents.
All those.
Respondents. Learned counsel for the applicant submits that since there are some developments after filing of the instant interlocutory application, namely at the time of filing the instant interlocutory application, no execution case was pending. However, the respondents have instituted an execution case for execution of the decree impugning the connected regular second appeal. She submits that, therefore, the petitioners applicants have filed another interlocutory application, namely 1 IA 1845/2026, and in view of this same, the petitioner no longer intends to pursue the instant interlocutory application and seeks leave of this court to withdraw the same. The learned counsel for the respondent has no objection to the same, hence the prayer is allowed. This interlocutory application is dismissed on withdrawal. Yes. Now,
We may come to annexer number 3, that is page number 44. So when the bailiff went, only then we came to know that there was a execution case that was filed on 18/2 of 2026. And that petition is annexed here with the two petitions, 400 and 401. And both are annexed as Annexa 1 in page number 28.
Your RSA is yet to be admitted.
However, we are in a situation where we have alleged fraud, which is nearly proved.
Yes, Mr. Mukherjee, you have any?
Stay will be consequence of, if it is order 40, if it is, I understand it is filed under
Under 41 Rule
Rule
5.
5, then it will be in consequence to admission, Your Lordship. In that case, admission has to be taken up first. The matter has to be taken up for admission first. There has to be substantial questions of law on which this matter can be admitted. If Your Lordship
I
pleases
beg to disagree with him.
if Your Lordship wants to, pleases to release it from Pathad as Your Lordship was expressing, then a date may be fixed for the matter to be taken up for admissions immediately.
And I beg for your lordship not to release it from Patha. You have already heard extensively. Now we are reaching absolutely in the conclusion. They have not been able to prove that the fraud has not been committed. Not only that, the normal citizens are not concerned about how many laws are laid down. They are know that they have a right, they have a title, and their right and title has been infringed upon with due process of court. So we have to give relief to them. It may not be released, and we have to reach conclusion as soon as possible. And we have annexed all the documents as well of title.
You respond against this interlocutory application.
The interlocutory application can be taken up for consideration once the matter has been admitted.
No. Our submission is that considering the urgency,
Yes,
as the execution case has already been filed, earlier you undertook not to pursue execution,
that's the main.
but now, as execution has been filed,
Behind the back,
so if you interrupt, then I will dismiss it. So you may file an objection against this interlocutory application. We'll fix a short date. Till then, the execution should not be pursued.
Taken up for admission hearing, Your Lordship,
Yes.
in a shorter date.
for that, I need to file another set of documents for the admission hearing.
This is
itself,
a protracted way of
because
extending the
no,
execution.
that is because,
Sufficient time was given to you.
but I didn't still get some of the certified copies. So because the certified copy person was
Then we will not execution to hold.
no, let him
When is the next date? Before the executing court?
in July.
When? When?
8th of July, actually. In
We'll fix this case before that date.
because it is becoming very urgent now, even though all the documents are here, even though we have right title interest, everything in our favor. Most importantly, they're trying to take our house away, which is not even within the suit land.
They have the decree.
That they have the degree and which they have obtained fraudulently.
Heard Miss Isaiah in IA number IA number 1845. Heard Miss Isaiah, learned counsel for the applicant slash applicants. Also heard Mr. B.J. Mukherjee, learned counsel for the respondents. This application under Order 5, Order 41, Rule 5 of the Code of Civil Procedure has been filed by the petitioner, by the applicants, praying for stay of execution, stay of the execution of the impugned decree in title execution case number 11/2026. Learned, on the other hand, learned counsel for the respondent submits that the connected regular second appeal 236/2024 is yet to be admitted, and unless the said appeal is admitted, this interlocutory application may not be considered. He therefore seeks some time for filing written objection in this interlocutory application and prays for listing the connected regular second appeal number 236 for execution, for admission. What will happen to the execution?
So if it is fixed before the next date of the lower court, I think it will be good.
The execution needs to be stayed.
No.
What
What was the order passed in the execution court?
Execution court order itself, I was trying to bring
What
attention
was the last order?
to submit the appellate court's stay. So certified copy.
Where is the,
submission.
which page?
Page number, so it's 45A. So for both 45 and 45A.
Okay. So execution court is not going for execution till that day. Therefore, we on perusal of order dated 8/4/2026 passed in title execution case number 11/2026, it appears that the executing court had fixed 8. You said that it is in July.
File the filers.
When is the next date?
This case, we try to file.
No, when is the next date?
The next date is in July. But slightly at loss with the exact date, but either it's 7th or 8th. My CS is not with me. So in July, was it
For filing
7th of July?
filing the certified copy of the stay order by this court, and learned counsel for the applicant submits that the next date is fixed on 7th of July. Therefore, let this matter be listed for admission hearing on July. Okay, 25th of June. List according.
Much.
Item 16.
Yes,
Put for my admission.
you are not audible. Be louder.
Let it come for admission.
Why it has come up for orders column today? Who has filed it? You are not pressing for the interlocutory application. You are not briefed. You have not gone through the records. Go through the record. We'll take it up after some time. Yes, Mr. Bora, what? Go through the record before you make submission. We'll give you some time. Then you make your submissions. Okay.
Item 17.
Indeed, we have already stated that the two states matter upon the complainant matter, but satisfied is yet not. We have already took, but last year, in the last occasion, Honorable Court directed the additional PP to contact the police station matter concerned.
Yes, Mr. Bashir. Heard Miss A. Gayan, learned counsel for the petitioners. Also Mr. K. Bashir, learned additional public prosecutor, appearing for respondent number 1.
It has been taken for police station.
But when you have taken steps through police,
As per office report, that is awaited, service report awaited, my lord.
no, 15th of May you took steps by speed post only. So speed post report has already come without showing that insufficient address.
Then, my lord,
Thereafter, you have taken steps for issuance of notice through police station? No.
that is
You have to take steps. Stop. It appears that the notice which were earlier issued to respondent number 2 through speed post had written without service. However, there is no indication in the record that the petitioner has taken steps for issuance of notice through jurisdictional police station. Hence, the petitioners are directed to take fresh step for issuance of notice upon respondent number 2. Through the officer in charge of Boshishta police station within 15 days from the
one petitioner, his probation period is going in IIT, my lord. Because of this, my lord,
within 7 days from the date of this order. But you have not taken steps
that is my mistake, my lord.
within 7 days from the date of this order returnable on
I thought it, because of, my lord, the hard probation
for
period.
vacation. 25th June. The additional public prosecutor is requested after the petitioners take steps to also intimate this court regarding the fate of the notice issued to respondent number 2 through officer in charge of jurisdictional police station on the next 8 weeks, list accordingly.
Your service may be provided.
Yes, I am not reflecting
Yes,
here.
And
But-
And this of item 3 and 4.
Oh, আপনার এখানে লাগে।
and should stay in item number 7, its stay is there, my lord, that may be confused.
The interim stay granted earlier shall continue till next day. What is this?
Filed a criminal petition under section 488.
Eight.
It has filed a criminal petition against the interim order dated 30/08/2022. Has been passed by down at additional section just Kamrup, Amritsar, whereby allowing the Jimma of the deceased Erica Nut in connection with Gauhati CRPS case number 77/2022. Lordship, the interim order is at page 36, Lordship, dated 30/08/2022, whereby the learned additional session just come up has
Page number 36.
allowed the Jimma of the these articles. that
No,
is
it is 35.
36 in my petition.
Initial,
Lordship,
okay, 36.
the lordship got it?
Yes.
Dated 30/08/2022, whereby,
Judgment in criminal division number 42.
yes, lordship,
Okay.
whereby the Planet Trial Court has directed to hand over the Jima overseas articles to the petitioners. Lordship, to that, against that order, we have come for criminal petition crossing of the said order, lordship. And my grounds are kindly come to page 4 of the petition, paragraph 3, lordship.
Yes.
That the petitioner begs to state that thereafter the IO of the case file is later dated. So the authority to ascertain
What are the facts of this case?
facts of the case is that, lordship. Kindly come to the FIR. That is it.
You can brief me, what are the
Yes,
facts?
it's page 21, lordship. The FIR. May I read the FIR?
Yes.
The facts in nutshell is this, lordship. I'd like to report that source information has been received that 2 trucks bearing registration number so and so are carrying illegal Burmese supari, and the same are in the process of either unloading the said supari, loading the said supari at plot number so and so of Brahmaputra Industrial Park in Boripur. It was also informed that the said supari was transported illegally, and the business in supari is being carried out from the area without any valid legal papers. The persons dealing in the said business have prepared fake documents to hoodwink the police, transport, tax authorities, and the drivers usually produce fake papers if they are caught during transportation. The papers usually show that some of the items are being transported while covertly Burmese supari is being transported. They also produce fake papers to evade the due taxes to the government and to show that the business is legal, thus causes losses running into crores to the state exchequer. It is also suspected that this supari is collected from sources who pilferage, steal the same from owners, other sources, and steal the same to persons, agents, businessmen dealing in such stolen supari at the black market. It is also done as part of a criminal conspiracy to cause wrongful loss to the state and wrongful gains to the business. Apart from the stated trucks, it was also informed that illegal stocks of Burmese supari are being stored covertly in various godowns inside the Brahmaputra Industrial Park. So, lordship, accordingly, investigation has started. And lordship, kindly come to page 34. Order dated 24/06/2022, whereby the Dalit Court has, in the other occasion, directed the IO to submit a report, Kimma report, in regard to the seized Arekala stock. Accordingly, on 24/06/22, the Dalit Trial Court has given a finding. May I read the order, lordship, at page 34, lordship?
Yes.
Mr. Lordship got it. Case report received along with so-and-so report of the IO called for in the matter of Jima prayer by so-and-so. The engaged counsel for the petitioner has filed Haziras in the petition, hard peruse the report so-and-so. After having gone through the IO's report, the IO's report reflected that during the course of investigation of the case, the examination report has been collected from ICAR, Central Plantation Crops Research Institute, Kasaragod, Kerala, through the Directorate of Horticulture and Food Processing, Assam, Khanapara. In the state report, it is clearly mentioned, lordship kindly might note it, the samples are falls under unsatisfactory category as per PROCEEDINGS regulations 2011 and 4th amended regulations. Norms samples are having higher value for fungi, which indicates as unsatisfactory category as per analysis report of Central Plantation Court Research Institution, Kerala. As per fungi morphology, which are found in the samples are having mycotoxic potential. Further, the report has indicated that improper processing adopted, which is unlikely adopted in India. And more particularly, Lordship, kindly come to the last line. On the basis of the analysis report, cis supari are not suitable for human consumption. To that report, regarding the seized articles, IO has given a report that those articles, cis articles, are not fit for human consumption, which may causes endangers of life and well-being of the public at large. So thereafter, Lordship, as page 36, the learned trial court has passed an order whereby direction has been given to the authority concerned to hand over Jima of the seized articles to the petitioners on terms and conditions concerned in the judgment, which against whom we have filed this criminal.
No. Trial court rejected your prayer. They went on revision.
Petition Lordship, they has rejected our prayer, rejected the prayer of Jima Lordship in the earlier occasion.
No, this order says that the prayer for Jimma was rejected.
No, Lordship.
You read last line, not fit for human consumption. Hence, IO
The
not.
act is directed to hand over the Jima of the.
Where are you reading?
Page 36, Lordship. Page 36.
No, why you jumped from?
Lordship, I'm sorry, Lordship.
You were reading order dated 24/6/2022.
Thereafter, that has been rejected.
Yes.
Jima petitioner of the petitioner that has been rejected.
Yes.
Thereafter, they have filed a criminal revision,
Yes.
whereby the prayer of
That
Jima
is for.
allowed. Yes. Lordship.
Yes.
That is at page 36.
You are against the revisional order.
Revision.
Yes. Now, what are your grounds?
Yes, Lordship. The grounds are there. The Lordship will find at page 9.
Page.
Page 9 of the petition. Lordship. May I read, Lordship?
Yes.
Ground number 1. For that, the learned court below, while allowing the Jimma to the respondent, has arrived at an erroneous finding, and as such, the order dated so and so is liable to be interpreted and same should be set aside. Number 2, Lordship. For that, while passing the impugn order dated 30/08/2022, the learned court below has wholly misconstrued the law laid down by the Honorable Supreme Court regarding grant of Jimma of the cis article. The Honorable Apex Court does not envision that custody of the narcotics should be given to the accused.
These are not narcotics.
Lordship. Yes, these are not narcotics.
Neither it is liquor.
Yes. Lordship, kindly come to paragraph 3, ground number 3, Lordship.
Yes.
For that, the learned trial court below, while passing the order, has failed to appreciate the fact that respondent has failed to produce any documents whatsoever to prove his ownership of the seized betel nuts. So, in fact, Lordship, the issue is regarding ownership of the seized betel nuts are under still investigation. So, it is still under investigation to ascertain the ownership of the seized areca nuts. Lordship. The learned trial court, revisional court, trial court has without giving proper finding as regards the ownership of the seized betel nuts.
On what basis the revisional court granted Jimma? What was the reasoning?
Yes, Lordship, could that be good?
Whether revisional court arrived at any finding regarding
Yes.
why it gave Jimma to the respondent?
I'm coming to the findings of the revisional court. Lordship, in this regard, the case diary was called for also. Can I submit? The impugned judgment, the trial court. Judgment.
It's 36.
No. Lordship, the criminal revision petition whereby the judgment was given, that your lordship will get it at page 38. Starts from page 38.
This is the impugned judgment.
Yes, Lord. It's a long judgment, Lordship. And more particularly, Lordship, paragraph 39 and 40, Lordship. Has a Lordship, okay?
Yes.
Hence, the IO is prayed for destruction of the cis supari in the interest of safety of human life. Paragraph 40, it is relevant to mention that the report of the ICR has not been enclosed with a report of the IO. Hence, there is no possibility for any opportunity for the petitioner side to rebut the report. Moreover, there was clear direction from this court as well as from the learned court below to submit reports as to ownership along with the verification report of the concerned officer. But it appears that the IO has not abided by the direction of court. Further, there was many issues such as how the sampling was done, whether the sample drawn and sent to horticulture was a true sample of the whole lot of the super, etc. Whether it is not clear as to what the expression samples are false under unsatisfactory category as per PROCEEDINGS norms. And since us, Lordship, thereafter, point number 42, Lordship. However, on the receipt of this report of the IO, the learned court below has rejected the JIMA petition by impugned order dated 24/6/22 by stating that in view of the report of the IO, this court deems it fit for not giving the JIMA of the 6 articles to the petitioner at this point of time. Thereafter, in view of this court, the impugned order dated 24/6/22 is improper and bad in the eyes of law and hence liable to be set aside on the following grounds. The ground number 1, Lordship, the report of the IO dated 21/06/22 and 24/6/22 are same in content. And receipt of the report dated so and so, the learned court below did not allow the prayer of the IO for destruction of the goods on the grounds of the goods being unfit for human consumption and directed the IO to report regarding the ownership. But on the receipt of the same report of the IO, on 24/6, the learned court below has accepted the same and rejected the JIMA petitions without reporting any finding as to the ownership of the goods and why it is not paid for giving in JIMA for the petitioners. So, and again, Lordship, thereafter, the case under which the goods were seized relates to allegations of theft or receiving stolen goods and forgery of documents, but the IO, in spite of getting sufficient time to verify and investigate, did not take the required steps to ascertain the genuineness of the documents which were furnished by the petitioners to show that they are the owners of the seized goods. As stated by this court, in its previous order in criminal revision case dated so and so, on the same issue, merely sending the documents to the concerned officers does not amount to verification. Further, the reports of IO is silent as to whether the goods are of.
So your one ground is that without ascertaining ownership.
Yes, next ground is Lordship. Point number 3. In support of the claim of ownership of the seized goods, the petitioners have inter alia submitted tax invoice, e-way bill, GST registration certificate respectively. So all these documents were endorsed by so and so Gauhati. On perusal of the documents with the endorsement, prima facie it appears that the documents are genuine. The tax invoices shows that the goods were to be transported on 10 to 12/22 by the petitioner respectively. And these are the two grounds, Roshan, because they have shown e-way bill, tax invoice, GST registration certificates. So whether these are sufficient to ascertain the ownership of the seized aircraft structure. So this is my conclusion.
What else?
That effect we have given our grounds, Roshan. Page 10 of the petition, round number 3. The learned trial court below, while passing the order, has failed to appreciate the fact that the respondent has failed to produce any documents whatsoever to prove his ownership of the seized battle nuts. In fact, the issue regarding ownership of the seized battle nuts are still under investigation. Only showing the tax invoice, e-way bill is not sufficient enough to ascertain the ownership of the seized article structure.
Where are our Eric now after 4 years?
Lordship, that is still under process. Investigations are still going on, Lordship. To that effect, also CD was called for, and we can produce a signature. It's a voluminous transaction.
What is the status?
Present status, Lordship, it was records are not up to date. It is last 5/12/2000.
Is there any stay in this criminal petition?
Yes.
Stay of the impugn
Yes,
order is there?
yes, Lordship.
Okay. What else is your ground?
Thereafter, Lordship, once it is reflected in the IO's note that it is not fit for human consumption as per food safety and sanitary regulations, if these zimmas are given to the petitioners, there is every possibility that he may sell the areca nuts in the open market, thereby endangering the life and well-being of the people. And the learned trial court has miserably failed to foresee such a situation. As such, the impugn order is bad in law and to be set aside, Lordship.
Anything else?
And point number 6 also, that is at page 12. Further, the learned trial court below has failed to appreciate the fact that a sample of the seized betel nuts suspected to be foreign origins had been sent to the competent authority to ascertain whether they are of foreign origin or local origin. Without waiting for any conclusive finding regarding origin, if the custody of these illegal consignments is handed over to the respondents, it will tantamount to giving the custody of the object of crime to the criminal himself that facilitated the respondents, fulfilling the nefarious and illegal design structure. So these are my grounds whereby Lordship can be set aside the impugn order dated 38/2022, whereby Jima has been given to the petitioners without ascertaining the ownership of the petals.
No, not without ascertaining. Court came to a finding that the documents which are produced before that court, it gave a finding that prima facie they appears to be genuine.
The basis of taxes for invoice e-way bills, Lordship, that ownership cannot be ascertained.
What is required?
Lordship, at least they have given without proper and valid documents, they have transported those purported to be stolen articles, Lordship, without having any proper documents.
What proper documents?
These are understood, whether they have got authority to transport the areca nuts. So that documents they have failed to give before the investigating officer, Lordship. And still, Lordship, since the case study was called for and it was not up to date, Lordship may kindly give us some time so that we can produce the present status of the.
No, after 24 years, this matter has come up for hearing. And investigation may go on. The limited question is whether the custody is to be, is there any wrong in the revision court's order or not?
Okay, kindly give us a date, we can submit more to the,
What?
I can prepare something more so I can give some judgments to that effect. Lordship.
Let us hear the other side. Yes, Mr. Vishwas, the additional PP is seeking time to.
That 2 years,
No,
maybe a point.
Lordship,
4 years have already elapsed, another 2
just
years.
after Lordship, before vacation or after vacation, immediately after vacation.
My lord,
Okay, let me hear the other
my lord,
side.
see when it was listed, before this date when it was listed, my lord, may kindly see the record.
No, we are disposing of this matter. Let me hear
And then
if we require your assistance.
it was listed this very week on the request of the learned public prosecutor. This was posted today. Your lordship may see that or it is there on record. It was listed on Monday.
In the earlier occasion, Lordship, it was came before your Lordship on 2804. It was last week perhaps.
This week, Kumbar.
Yes.
Then an ardent request was made in view of the fact that it is pending since 4 years, that it may be taken up on
PD was
Thursday.
called for, but
No, otherwise, Ms. Bora,
Lordship.
after completing your submission, you have prayed for some time.
Yes.
That prayer ought to have been made before starting
Yes.
your submission. Now I may give you time after hearing him for furnishing judgments only, not for rehearing. Let me hear him.
Obliged.
Yes.
No, my lord. Your lordship has already noticed, my lord, there is a case where some perishable goods are being kept in the possession of the police for last.
Areca is perishable. It has already perished.
So if it is perishable, my lord, though it has certain lifetime, unlike other vegetables, but it also have a limit, my lord. Now, my lord, these are areca, my lord, I'll just indicate certain things because, my lord, there is a hidden agenda behind such supari cases. My lord will see under what section this case is registered. I am constrained to use the word modus operandi by the police official in connivance with some people who are in this business. My lord will see under what section this case has been registered. This case is registered under section. Page number 21 is the FIR. What does the FIR say? The FIR is more in the nature of a PIL petition. My lord, I want to reread the FIR, page number 21.
Yes.
I would like to report that source information has been received that 2 trucks bearing registration are carrying illegal Burmese supari. I take a pause here, my lord. So their first suspicion is the suparis are Burmese, illegal Burmese supari. And the same are in process of either unloading the said supari or loading the said supari at plot number such and such of Brahmaputra Industrial Park at Gauripur. It was also informed that the said supari was transported illegally. So the transportation is illegal and business in supari is being carried out from the area without valid legal papers. The person dealing in the said business have prepared fake documents. Then they say first Burmese and the documents which they prepared are fake documents. To hoodwink the police, transport tax authorities and the drivers usually, my lord will just take note of the words. Usually, the drivers usually produce fake papers. If they are caught during transportation, the papers usually, is it a PIL petition? The papers usually show that some other items are being transported while
covertly Burmese supari is being transported. They also produce fake papers. These are all apprehensions. They also produce fake papers to evade the due tax to the government and to show that the business is legal and thus cause losses running into crores to the state exchequer. It is also suspected that the supari is collected from source who pilferage, steal the same from owners, other sources and sell the same to person, agent, businessmen dealing in such stolen supari in the black market. It is all done as a part of criminal conspiracy to cause wrongful loss to the state and wrongful gain to the businessman. Apart from the stated truck, it was also informed that illegal stocks of Burmese supari are being stored covertly in various godown inside Brahmaputra Industrial Park. So, my lord, if I have understood the FIR correctly, they have come up with 3-4, my lord, unconnected allegations. Initially, they say that these are Burmese supari. If it is a Burmese supari, that why the police are involved? What is the interest of the police? If it is a Burmese supari, it should go to the excise. They should have intercepted and forwarded it to the excise department. It is inter-country smuggling is under the jurisdiction of the state excise. Will the Assam police investigate? That is where I want to show their actual interest in this case. Then the second limb of allegation is what? That usually these drivers produce fake documents. Now, what are the fake documents produced in this case? Nothing in the FIR. They think that they are very smart. Then they say, usually these are stolen from some source. From which person? These have been stolen 4 years down the line. Let them show the name of one person. Then they say whether there is any FIR from any third party with regard to theft of 350 bags of supari. I will demonstrate what is their actual intention. Only because they were not satisfied with some bargain, this FIR has come up. From facts I'll show it. Then, my lord, they registered is under 120B 379, that is theft, IPC. No allegation from whom it has been stolen. 411, dishonestly receiving stolen property. That is also prima facie, there is no allegation. It's a case for quashing, in fact. Then came 420, cheating. Whom did I cheat? How? 468, forgery. Which document did I forge? Just because the government is giving you an IPC free of cost, you'll pick all the sections.
465 also.
468, the section is 468.
Before that, 465.
465 is also there. Maybe, my lord, that is also forgery, I guess, I suppose. 471, using as genuine a forged document or electronic record. My lord, let them indicate which document which was in fact forged and which I have used as a genuine. Rather, the findings are absolutely otherwise. So this is how they have intercepted my suparis. Now, my lord, after 13 days, they furnish a report before the Honorable Additional Chief Judicial Magistrate, page number 23, my lord will see. Now, my lord, this theft part has gone now. 379, 411, 420, 468, 471, everything is now gone. Now they are on some expert test reports. That also I'll show. The Honorable Additional Chief Judicial Magistrate, page 23. With reference to the above, I have the honor to state that based on the FIR such and such, investigation was carried out and 2 trucks bearing such as containing suspected Burmese supari, as per version of triber, were seized by such and such. The seizure was reported such and such. It may be stated that the seized items were voluminous in nature. The drivers also could not state anything about the owner, point of origin, or the exact quantity of the supari. Post seizure, on the night of such as that, the vehicle containing supari caught fire. Now the vehicle caught fire. And in this regard, Chancery PS case number such and such has been registered and is under investigation. That investigation will never see the light of the day. Seized vehicle and supari were partially damaged. The competent authorities have already been intimated to impact the impact the supari and report as to the weightage, quantity, etc. of the undamaged supari, and also as to whether the same is fit for human consumption, etc. Now, my lord, I take a pause here. My lord will kindly appreciate what they have done after seizure. They allowed some people to unload a huge some bags of supari. The police allowed them. And to camouflage their illegal act, they burned the vehicle. The separate cases are pending against it. I will not bring those here because here is a limited question of Jimma. In connection with the case such and such, no one has appeared before the IO claiming ownership of the vehicle or the supari. Investigation is underway for identifying the owner. However, as per online report, the truck owners are such and such. In respect to supari, the
Who are you?
I am the owner of the suparis.
No,
Oh.
amongst number 1 and 2.
I am, my lord. Yes, sir. Om Sai Trading Company and SN Trading Company. I am not the owner of the vehicle. I am the owner of the consignment. In respect of the supari, the investigation is underway and the name of the actual owner is being ascertained. And the name of the actual owner is being ascertained. It may be stated herein that the same trucks and suparis have also been seized in connection with Chancery PS case number such and such, and the said case is also under investigation. If Jimma order is granted now, it will have a great impact on investigation, and as such, the prayer may kindly not be considered favorably. If the Jimma is given to the suparis, I do not know, my lord. Probably the investigating agency are under the impression that the Jimma, that the suparis will certainly come alive and they will give some statement implicating somebody. That may be the only reason. Some black magic will happen. Suparis will start speaking. Page 25. Now the learned magistrate, simply quoting what has been stated in the report without any application of mine, have rejected my prayer of Jimma. My lord will see the way how the Jimma petition was dealt. Page 25. Petitioner is duly represented by learned counsel. Case record reveals along with the report called from the IO representing Jimma petition number such and such. I already filed Jimma. Filed by the petitioner Dhinanta Sivkumar Maurya seeking Jimma of seized Erekanat and etc. Seen the petition heard. The petitioner submitted such and such Erekanats belonging to the petitioner loaded in 2 trucks were seized by police in connection to this case, and if the seized articles are not furnished, not further required for investigation, the same may kindly be released to the petitioner. Under the aforesaid circumstance, the petitioner have prayed for giving Jimma of the seized Erekanat and vehicle number. Peruse the case record, peruse the report. On perusal of the record, it is found that wide amount number such and such loaded bearing number so and so, this is a truck number seized in connection to this case. The IO in this report stated that the vehicle bearing registered number such and such containing suspected Burmese shikari were seized in this case, and samples were drawn and sent to appropriate authority for analysis. The post seizure on the night of such and such, the vehicle containing supari caught fire. These are just picked from the IO report, these lines exactly. Seized vehicle and supari are partially damaged. The competent authority have already been initiated to inspect the supari and report as to the weightage, quantity. All this, the authorities are yet to inspect the supari and certify, etc. IO further reported that in connection with the instant case, no one has appeared before the IO claiming ownership of the vehicle or supari. Investigation is underway for identifying the owners. In respect of the supari, the same is also underway. Investigation and name of actual owner is being ascertained. The same truck and supari have been seized, such as under aforesaid circumstance, IO prayed for not granting Jimma. And the wonderful explanation is, in view of the above report, the IO, the instant Jimma petition is rejected. IO said such and such, in view of this, I reject. That is why the learned session judge interfered. He said that the learned court below should have applied his own mind in rejecting, not because the IO is saying something. Then, my lord, the same fate also, because there was a second jimma before the same learned magistrate, where again a report was called. The same standard reply by the IO that investigation is underway. We are waiting for the owner and all these things, which your lordship will find at page number 25. Sorry, my lord, page number 27. They say agriculture department did not file damage report. Owner appeared with documents which are awaiting verification. They say now they say that the owners appeared with documents 2022, my lord. And in 26 also a submission was made that verification of the owner is yet under investigation. 2022 March, page number 27.
Which para?
2%, last para. 2%, Dinanath Moria, the petitioner, the respondent before your lordship, and Manoj Srinath Moria appeared along with copy of PRS bail order passed by the Honorable High Court in AB number such and such. They also produced certain documents in support of their ownership claim of Supari. The said documents are being verified by government authorities like tax, etc. to find out if the claim of ownership is genuine. The said process is underway. Now, my lord, thereafter, my lord, a report was called that whether it was in Burmese or indigenous. Page 32, my lord, will see the report. The report is from, my lord, it is written in Hindi, Central Plantation Crop Research Institute, Kasargaon, page number 32. Other observation.
Yes.
My lord will see observation number 2, because now there, my lord, the sections under which the case was registered, now those section has gone for a toss. Now they are not talking of those sections. Now they are only on Burmese. Against that, what does the expert report say? Indigenous or of foreign origin of the materials may not be identified as the nuts underwent processing. So now, my lord, I put a question to myself, what is the basis of retaining my suparis? Only because I have not danced to their tune? Is this how, my lord, the police will, my lord, the authorities will deal with, my lord, genuine businessmen? Now, my lord, now I will demonstrate before this court my credential as an owner. My lord, your lordship has asked that what more ownership document than tax invoice, EY bill may be recovered for agricultural products. My lord, I do not know last time when cabbages were sold through sale deed. I do not know when apples were sold through sale deeds. In my last 19 years of practice, my lord, I have never made a sale deed for vegetables and apples. For land, I can understand. For vehicles, I can understand. For supari, there cannot be sale deed. I'll have to pay the required taxes to the government, and I have annexed the tax invoices. They say that we have sent these tax invoices to the authorities to ascertain whether these are
No, their submission that it is found not to be fit for human consumption.
My lord, this is their third ground to retain my supari. First, Burmese. Second, stolen.
Ownership.
No ownership. Third, stolen. Now, chalo, something will hold on, not fit for human consumption. My lord, I have taken this instruction categorically from my client, because, my lord, I am, apart from my client's lawyer, I am also a citizen of this country, my lord. I also realize if contaminated things spread in the market, it might cause damage. My lord, these are raw betel nuts. These will undergo processes. My lord, if your lordship, if I may draw an analogy, cashew nuts, my lord, kaju badam, if cashew nuts are taken from the field and if directly somebody eat, my lord, they will have severe heart problem. The cashew nuts which you find in the market, these are all processed. After process, it is. These suparis will undergo process.
No,
These are,
but the A report from Central Plantation Crops Research Institute says that the betel nuts which were examined have
Correct.
already been processed.
No, my lord, this has been partially processed. Let them, because if they examine the process, my lord, there are a lot of, my lord, if I may take, there are a lot of gutka selling in the market. Now, my lord will just bear with me, my lord, because I have taken all these meticulous instructions. My lord, all these gutka products which are sold in the market, these are not made of fresh suparis. These are all, my lord, they undergo process and then they are sold into the gutka industry. My lord, these are sold. Government is getting tax. My lord, I cannot become a moral judge of all this, my lord. They are selling. These products are there in the market. Rajnigandha, for that matter, what not, my lord. Half of the name also I do not know. My lord, these suparis.
No, you come. These gutka etc. are made up of rotten suparis.
They undergoes process. The problem is, my lord, they are testing the unprocessed suparis.
No.
Let them, if they would, my lord, if they would have one bit of genuine intention.
Come to page number 32.
Absolutely, my lord. 32. Yes.
Second observation.
Yes. My lord, this processing is partial processing. This will go to the factories, to the respective industries. This will be processed. After process, let them, if required, the Jimma can be subject to the condition that before this could have been done long back, my lord. That if these were their grounds, then the Jimmas could have been subject to the condition that before they have been sold to the public, a report from such and such laboratories should be obtained. Those would have been better condition to save the interest of both the state and the individual. These are partially processed. Definitely, my lord, this will not be fit for human consumption. Then, my lord, will come to the. Then again, my lord, page 33, a fresh police report was called for. Now, my lord, every 2 months they're developing upon their own case. Now, in the month of June 2022, what is their stand? Now they have given up all other, my lord, allegations. Now they say that it may have an adverse impact on human life. My lord will just see the change of strategy. Now, where is 460? This case, still case diary is there. Why, my lord, they are not charge sheeting me? Because they know there is no ingredient of any of these sections.
To that regard also, I have to take instruction.
The case diary is here, my lord, what instruction?
Because it was the old version, it is up to Lordship itself, recorded up to.
Include your argument.
My lord. Now, my lord, they are not filing the charge sheet because they know there is no ingredient of all this section under which this case has been registered. This is my submission. Now, my lord, will kindly see page 30.
No, we are not examining those aspects.
Now, the Jimma. Now, my lord, page 33, the last para. Now, their case is that it is not fit for human consumption.
Yes.
Now, my lord, criminal revision. Thereafter, my lord, I come to the rejection order, page 34. Here also, my lord, the learned magistrate, page 34. I'll just cut short the arguments. Page 34.
Yes.
Your lordship is rising?
No.
Okay. Page 34. The second Jimma, which was again rejected, the operative part, page 35. The same, my lord, in view of the report of the IO, this court deems it fit for not giving Jimma. Page 35. Thereafter, my lord, we come against this. We file a revision at the order of revision is page number 38. The revisional court has taken each and every aspect into consideration, my lord. As far as the ownership is concerned, your lordship will come to para number 54. Sorry, page 54, para number 3.
Yes.
In support of the claim of ownership of the seized goods, the petitioner have inter alia submitted tax invoice, e-way bill, GST registration certificate respectively. All these documents were endorsed by one Alok Kumar Singh, Superintendent, Anti-Evasion, Central Goods and Service Tax, Gauhati. On perusal of the document with the endorsement, prima facie, it appears that the documents are genuine. The tax invoice shows that the goods were to be transported on 10/2/2022 on the day when the trucks were seized by the petitioner respectively to Balaji Trading Company, Delhi and to KNG Traders, Karnataka. As stated, the IO could easily ascertain whether the signature of the superintendent is true or false, or whether such person do exist in the office or not. But the report of the IO is silent on this aspect. In spite of clear direction of court, hence in the absence of anything to the contrary, the documents are presumed to be genuine and true. Moreover, there is no one else claiming ownership of the goods. Hence, it appears that the petitioner are the owner of the seized good and hence entitled to the possession thereof. The learned trial court has failed to examine the document produced by the petitioner in proper perspective and give its finding thereon. Further, the report of the IO regarding fitness of the goods of human consumption is not enclosed with the report of the ICAR Kasargaon. Even if this fact is ignored, there are issues as to whether the sample are properly drawn and whether it truly represents the entire good or not. Unfortunately, these issues cannot be ascertained from the report of the IO dated such and such and such. Hence, merely on the basis of cryptic report of the IO, the owners of the goods cannot be denied interim jimma of the same during pendency of the trial. And hence, the jimma was granted, my lord. Because, my lord, at the end of the day, my lord, an opinion of an expert is an opinion. Your lordship is aware, my lord, it's an opinion under section 45 of the Evidence Act, but that remains as an opinion. That's not an evidence. Now, my lord, how the prosecution or for that matter, state have conducted this matter, that also needs some consideration and I'll have to submit on that as well. My lord, against this order of jimma, two persons filed criminal petition before this court. If your lordship kindly, I beg your lord's indulgence to the same judgment, page 56, para 45. So jimma was granted on furnishing of bank guarantee. My lord have seen? Page 56, upon petition, page 56. Last one, page 56, para 45 of the judgment. My lord is there, my lord?
Para?
45 of the impugned judgment.
Yes.
Jimma on the condition of furnishing bank guarantee. My lord, may kindly take note of this bank guarantee. My lord is there.
Yes, bank guarantee.
My lord, my submission is on the word bank guarantee.
Yes.
On bank guarantee. Now, my lord, I was also aggrieved by this judgment that for bank guarantee, I'll have to keep equal amount of money in the bank. And they were also aggrieved with this judgment because this judgment talks of granting jimma. We filed a criminal petition challenging this for modification of this bank guarantee. To order to proceed.
What happened?
Yes. The High Court modified it to bond.
In which case?
And in the presence of the learned additional public prosecutor. That was not an ex parte order. My lord will take the connected contempt petition. Contempt petition.
Yes.
Page number 36. Page 36 of the contempt petition.
Perhaps state.
An order, no, contempt state cannot be, it is by name. Contempt is by name. Page 37.
No, this contempt is of which order?
My lord, the contempt petition number is 549/2023.
Alleging contempt of which order?
Alleging contempt of this order. Page number 37 of the contempt petition. Now, this page 37 is an order passed while challenging the order of jimma by the learned session judge because we were agreed by the bank guarantee condition. What is there at page 37 of the
Yes.
contempt? This is the judgment by His Lordship Justice Ajit Bhattakur. Here, my lord, the condition was modified. I'll just take to the operative part, page number 39. Page 39, para number 7. And then my lord will kindly take note of one thing, that this was passed in the presence of additional PP, the counsel for the petitioner as well as the counsel for the state. That is there on the first line itself.
Yes.
My lord will see that page 39, para 7, the modification, that this honorable court modified that condition of bank guarantee to the petitioner shall furnish indemnity bond. The bank guarantee was now, the condition is modified to indemnity bond of equal value as determined by the learned court below in order dated such as. So that condition was modified. And this order, but my lord, this has a bearing time and again why I am saying that it was passed in the presence of the additional learned public prosecutor, because this has a bearing on the present present criminal petition which they have filed. Now, when they were not, my lord, when they were not complying with the order, we passed a contempt petition. We filed this contempt petition. Now, my lord, additional affidavit. Now, my lord, they had a stay order. Their stay order is prior to our stay order. That is, I mean, prior to the order passed modifying. 28/4/2023 is the date when they obtained a stay order in the present case.
28/4/2023.
And our order is 27/6/23. Our order.
Yours is later.
Correct. Correct. So then we filed a contempt petition. Then they say immediately they have bounced on us, suppressing fact and filing petitions. They have suppressed the fact that there is a stay order and they have the audacity to file a criminal petition and then move and come to contempt jurisdiction. My lord, their stay order was passed ex parte. My client did not have any standing counsel in the High Court. It was passed ex parte. Now, my lord, when an ex parte order is obtained, whatever little we have understood, we'll have to take steps and send a copy along with a copy of the interim order to the other side. Now, my lord, this is interesting. They obtained a stay order on 28/4/2023. My lord, 28/4/2023. This contempt petition came once for consideration on 8/8/2025. After 2 years. On that date, I appeared as a counsel. My lord, my lord, may kindly turn to the record of the contempt petition order dated 8/8/2025. I took instructions from my client. My client said, we have not received any such copy of interim order. On 8/8/2025, after 2 years. Then the learned single judge called for the record of their criminal petition as well as this contempt petition to see as to when they had taken steps in this case. Because the contempt petition was listed, I mean, it was not tagged then. Then when they made a submission that they have a stay order, then the court called for the records of the present criminal petition, and that is how this contempt and criminal petition got tagged on 8/8/2025.
Not 8, 10/11/2025.
The petition, and the respondent was
10/11.
10/11. When this was 10/11/2025, there is no order as 8/8 order.
There is no order on.
In fact, the present contemplation was listed on 8/8/2025.
On 28/4/2023,
Yes,
the ex parte
Yes.
stay was granted.
yes.
Next, the matter was listed on 10/11/2025 when you appeared before
Ah.
this court.
My lord, then my date. On that day, they had taken steps after 2 years. After 2 years, they had taken steps. That is from the office record, your lordship may see. This is how, my lord, this case has went on for last 4 years. My lord will see when they had taken steps.
14/8.
14/8/2025.
Yes.
Yes. Now, my lord, they are, in order to save their skin in the contempt petition, they are taking shelter of the stay order.
Okay, but stay order was there.
Stay order was. But the stay order was never got into the notice of the court when we got our order modified. Because that was not an ex parte. The order passed against me was ex parte. Now, my lord, as far as granting Jimma, my lord, I have already, my lord, extensively submitted on the Jimma. The order passed by the learned session judge, my lord, it is a reasoned order. It is in tandem with the mandate of Sundarbai Ambala, my lord. It is there is nothing, my lord, they could indicate as to how this order is erroneous.
Okay.
That's my humble and limited submissions, my lord.
Ms. Bora, you will be submitting some citations.
So far as Sundarbai Ambalali's judgment is concerned, Lordship, it has categorically stated that he has not yet proved the ownership, but the petitioner has still not proved his ownership to get the benefit of this articles, Lordship. So that direction
My lord
must be
will,
also.
my lord will just pardon
It
me.
cannot be given, Lordship.
Heard Ms. S.H. Bora, learned additional public prosecutor, representing the state, who is the petitioner in this case. Also, Mr. M. Vishwas, learned counsel for the respondents. This criminal petition has been filed by the state under section 482 of Code of Criminal Procedure 1973, impugning the judgment and order dated 30/8/2022, passed by the Court of Learned Additional Sessions Judge Kabru Amin Gau in criminal revision case number 42/2022, whereby the Jimma of seized Erica nuts, which were seized in connection with Changsari PS case number 77/2022, was granted to the present respondents. The facts relevant for consideration of the instant criminal petition, in brief, are that on 10/2/2022, one Shri U. Kolita, ASI of police, attached to North Gauhati Police Outpost under Changsari Police Station, had lodged an FIR before the in charge of North Gauhati OP inter alia, alleging that on receipt of any information through reliable sources that two trucks bearing registration number AS25CC 7741 and MH1888 AA 5354 were carrying illegal Burmese supari. And uh, and same is likely to be unloaded at plot number 60 C within bracket Chota Moja bracket close and plot number 94 within bracket Boro Moja bracket close of Brahmaputra Industrial Park at Gauripur. It was also alleged in the affair that the persons dealing in such business usually prepare fake documents to hoodwink police / transport / tax authorities. Stop. It was alleged that such illegal trade in Burmese supari cause loss to state exchequer, and same is done in done as a part of criminal conspiracy to cause wrongful loss to the state. Stop. On receipt of the said FIR, Changsari PS case number 77/2022 was registered under section 120 capital B /379/411/465/468/471 of the Indian Penal Code. Stop. It is pertinent to mention herein that after seizure of the said supari within inverted comma, on 23rd February 2022, the in charge of North Gauhati Police Outpost reported to the Court of London Additional Chief Judicial Magistrate Kamrup Amingao by furnishing a written report regarding the fact that on the night of 11th February 2022, the seized vehicle caught fire and some of the seized supari were partially damaged. Stop. It is also mentioned in the report that in respect of the said incident, another case, that is Changsari PS case number 78/2022 was registered. It was also reported therein that till 23/2/2022, no one has claimed the ownership of either the seized vehicle or the consignment of this supari. Later on, the present petitioners, next para, later on the present respondents claiming the ownership of the seized supari approach the Court of London Additional Chief Judicial Magistrate Kamloops by filing a Jimma petition. Stop on receipt of the said Jimma petition, the said court called for a report from the investigating officer, and thereafter, by order dated 23/2/2022, the Court of Additional Chief Judicial Magistrate Kamloops Metro rejected the prayer for Jimma on the basis of the report of the investigating officer. Stop. In the meanwhile, the meanwhile, the investigating officer filed another report on 25/3/2022, whereby wherein it was mentioned that the present respondents approached the investigating officer after obtaining pre-arrest bail in the aforesaid case, and they also produced certain documents in support of their ownership claim of the safaris. However, it was reported by the investigating officer that the said documents are under verification, and till the filing of the report, the ownership would not be ascertained by the investigating officer. Thereafter, the respondents again approached the Court of London Judicial Magistrate First Class Amin seeking Jimma of the seized consignment of Burmese suparis as well as vehicles. However, by order dated 24/6/2022, this time also the prayer for Jimma was rejected by the court. However, the reasons for rejecting the Jimma prayer was different, namely the seized suparis were found not suitable for human consumption, according to the report of Central Plantation Corps Research Institute, Kasargod, Kerala. and relying on the report of the investigating officer, the prayer for Jimma was rejected by the Court of Judicial Magistrate First Class, Amingau, by its order dated 24/6/2022, passed in Changsari PS case number 77/2022. Stop. On being aggrieved by the aforesaid order, the respondents approached the Court of Learned Additional Session Judge Amingau by filing a revision petition challenging the order dated 24/6/2022 passed by the before 6/2022 passed in Changsari PS case number 77/2022. Stop. Thereafter, by order dated 30/8/2022, the Court of Learned Additional Session Judge Kamrup Amingam had set aside the order which was impugned before it and granted the Jimma of the seized dried areca nuts on furnishing bank guarantee to the tune of rupees 47,22,375 and rupees 49,65,480 respectively. The said the order is under challenge in this criminal petition by the state. Ms. S.H. Hajorika, the learned additional public prosecutor, has submitted that the Court of Learned Additional Sessions Judge Kamrup Amingam has erred in granting the Jimma of the seized areca nut without taking into consideration the report of the without taking into consideration that the Court of Learned Magistrate, Learned Additional Chief Judicial Magistrate Amingam had rejected the prayer for grant of Jimma on the basis of a report of Central Plantation Crops Research Institute within bracket CPCRI, Kasaragod, Kerala, that the seized areca nuts were not suitable for human consumption. She further submits that the revisional court was also wrong in granting the Jimma to the respondents without ascertaining the ownership of the seized Jimma, seized areca nuts as the genuinity of the documents on the basis of which the ownership of these areca nuts is claimed by the respondent is still under investigation. These are two main submissions. You have anything else you may give in writing? Stop. In support of her submission, she has cited following rulings, dot, dot, dot. Stop. On the other hand, Mr. M. Bishwas, learned counsel for the respondents, has submitted that prior to prior to not prior to. On the other hand, Mr. M. Bishwas, learned counsel for the respondent, has submitted that the order which is put to challenge in this criminal petition has been partially modified by. You have that order. You have a copy of that order. Has been partially modified by a coordinate bench of this court in criminal petition number 624/2023, whereby the requirement of furnishing bank guarantee was modified into furnishing the equivalent amount of furnishing an indemnity bond by the respondents. He further submits that as the petitioners have, in spite of direction of the revisional court and after modification of the order which has been impugned in this case by a coordinate bench of this court in criminal petition number 624/2023, failed to comply with the same. The respondents had filed a contempt case, which is registered as contempt case number 549/2023. He further submits that though in the instant criminal petition by order dated 28/4/2023, the impugn order dated 38/2022, passed by the Court of Learned Additional Session Judge Kamrup Amingao in criminal revision number 42/2022 has been stayed. However, the respondents were unaware about the said order prior to their filing the contempt case, as the aforesaid stay order was passed by this court in the absence of the respondent number 2 and respondent number 1 and 2, and the notice in this case was issued only on (14/8, 2025), and therefore they were not aware about the stay granted in the instant case. Therefore, the respondents were not aware about the stay granted. He further submits that the Court of Learned Additional Session Judge Kamrup Amingao has rightly granted the Jimma of the seized Harikana to the respondent number 2, as the documents on the basis of which the present respondents claimed ownership of the seized goods, namely tax invoice, e-way bill, GST registration certificates, which were all found to be prima facie genuine by the said court. He also submits that in spite of the direction of the court to verify the ownership, verify the genuineness of the aforesaid documents, the IO failed to ascertain as to whether the documents are genuine or forged. Hence, he submits that the revisional court was not wrong in granting the Jimma of the seized Harikanads to the present petitioner, to the respondents. Stop. Will you submit any judgment? The learned counsel for the respondent has cited following rulings in support of his submissions. Yes, Miss Bora, when will you submit You may take your time.
Then next week, Lordship.
Next week, I am giving a date. On that date, you,
Lordship.
both of you submit. Without the लिखोगा. Is SH for learned counsel for the petitioner, also Mr. M. Vishwas, learned counsel for the respondent. Though hearing is concluded, however, on request of learned counsel for both sides, they are granted some time to submit citations in support of their respective submissions. The learned counsel for the respective parties are also requested to give a one-page written gist of their respective arguments. Let this matter be listed again. 12th of June. Yes,
But it is meant to be 4th of July.
you take the consent of Mr. Mukherjee.
Take his consent, but the date of the execution case is 4th of July. Because the CS was also not opening and it went out of my head.
Or instead of 4,
Oh, instead of 7/7, it is 4/7. In the order it is reflected of the next day. We do not want to change the date of the court. We're just saying that in the order, the date of the next date of the execution case to be reflected as 4/7.
4/7, okay.
4/7, that's
Kone munmunlo sene. Okay, we'll make the corrections.
Here is connected with fourth.
Yes.
The gist will be something I don't know what you.
I am only dealing with item 3. 4 is attached only to facilitate the court to go through. I am not taking up that matter. If 3 is disposed of, 4 will go to the regular bench.
Timing until 16.
Yeah, I am sorry, I was not able. Here IA is for vacating the stay order, which was granted on 26/3/21. Now there are 2 counts, my lord, regarding the non-maintainability of the NIAC is that the check was presented after expiry of the validity period, that is 3 months. And second one is that, my lord, the notice was issued beyond 15 days. Possibly will not go because 30 days it was made in 2003, my lord, by amendment. Now regarding the presenting the case on, my lord, after expiry of the tenure, my lord, 3 months, my lord, I need some time because the check was of Khanapara branch, which was deposited at Nagaon, my lord.
No, what for this IA is there?
IA is for vacating the stay, my lord.
Stay has been granted.
My lord.
You are seeking time.
Time for obtaining that deposit slip, my lord, on which date?
This IA is filed by you.
My
By the respondent.
by the respondent.
Heard Mr. N.J. Das, learned counsel for the respondent / applicant in IA in the instant interlocutory application. Also heard Mr. M.K. Das. I am sorry, M.K. Bora, learned counsel for the petitioner / opposite party in the instant interlocutory application. Learned counsel for the respondent applicant / applicant has prayed for an adjournment to produce some authority
No, madam, some document regarding deposit slip.
to produce some documents in support of his case.
My-
The prayer for adjournment is allowed.
my-
How much time?
It's any date, madam.
let this matter be listed after 2 weeks.
Well,
The stay was still
it is operating.
Operating. That's a continuing motion.
okay. The stay granted in the connected criminal petition shall continue till next day.
Public.
Item 7.
Date.
Public.
Thank you so much. Your Lordship, in this matter, the report was last updated on 24/7/2025, Your Lordship. The OC was instructed to for further investigation and submit the report. As per our instruction, the report has been submitted.
No, I am not getting anything. What report?
There is a flag mark, my lord. Lordship may kindly see the arrow flag mark, my lord. There, my lord, an inquiry was conducted, my lord. So far, then a report has been submitted before the learned trial court, my lord. Perhaps the court is asking for that report.
By which order?
Orders. Last order.
Last order does not mention about report. It is silent. Prior to that order also. No, what is your submission? What report?
In his further investigation will be required in this matter as well. Regarding the
The order is also not very clear.
No.
The what for this criminal petition has been filed?
99,500.
Cash.
Yes.
Okay. Whether the investigation is going on or is complete.
Investigation is going on. Investigation.
Then produce the case diary. Up-to-date case diary. Heard Miss. Heard Miss. B. Soren, learned counsel for the petitioner. Also heard Mr. MP Goswami, learned additional public prosecutor. No, it is pending investigation or not?
It's pending, Your Lordship. Further investigation was directed.
By which order? Go through. Go through the record and then make your submissions. We will take it up after some time. In the second half, we'll take it up. You also go through.
Just one order I have found, my lord, in the. I will go through it.
Both of you go through and
Item 9.
Wait, please, Your Lordship. As per last order, Lordship, upgraded case diary has been called for. And as per information, it has not received.
My lord, application is not received, my lord.
heard Ms. N. Chaudhary, learned counsel for the petitioner. Also heard Mr. MP Goswami, learned additional public prosecutor, as well as Mr. P. New, appearing for respondent number 2. It appears that Learned counsel, learned additional public prosecutor submits that prays for some more time for production of uh, the updated case diary. The prayer is allowed. Let this matter be listed 20 July,
Worship, can it be on 21 or 22?
21 July. List accordingly.
Obliged.
Item 11.
Yes, what is this?
The interlocutory application for modification of the order dated passed by your lordship on 9th of January, lordship. That order is NHR 1, page 23 to 25, lordship.
Mason.
This I have been basically filed to vacate this stay. There has been for the order that has been passed by this honorable person. Now, my lord, instead of going to the missed case, let the matter finally decided and disposed of.
What was
Basically, we are paying for the vacating the stay order that has been already passed.
on 9/1 stay was granted?
9/1.
Stay on the proceeding.
Stay. That has been granted.
The appearance of parties is complete.
Appearance of properties.
Then we can hear the, instead of going for interlocutory application.
That will be better.
When?
Can it be on next week because the next date fixed by the learned trial court is 10th of July, lordship.
Before 10th of July.
That can be fixed easily before that.
Before 10th
I
of
will be
July.
ready, my lord, to argue this.
Okay. Heard Mr. B. Deka. In criminal petition. Heard Mr. B. Deka, learned counsel for the petitioner. Also heard Miss M. Bora, learned counsel for the. How many respondents are there?
Only one.
Learned counsel for the respondent. Though an interlocutory application has been filed by the respondent for vacating the stay, interim stay on further proceeding of CR case number 515/2024 for pending before the Court of Learned Judicial Magistrate First Class Kamrup Metro, which was passed on 9/1/2026. However, learned counsel for both sides are in agreement to the proposal that instead of taking up the interlocutory application, the criminal petition may be finally heard and disposed of. Stop. Accordingly, let this matter be listed 23rd June.
Yes. That is going to be the Tuesday. So argument can be easily done.
23rd June.
If you okay.
Obliged, lordship.
Item 12.
There is one request, my lord. Interim stay may be continued for the time.
No, that will continue. The interim stay shall continue till next.
If you.
Yes. What is this?
Yes, Lordship. This is a revision filed to challenge the order of the family court, Your Lordship, where the family court has given the maintenance, interim maintenance from the date of filing of the suit itself. If I
When it should give, it should have given.
The interim maintenance should have been from the date of order, Lordship.
No, on that point, law is very clear.
Yeah, so
On the point of final maintenance, it is clear, Lordship, but interim maintenance is always from the date of order, Lordship.
Okay, we'll hear. Today you are ready? Okay.
they're not, although he has been paying for the child's this thing, but he has also been threatening me off the record, saying that he will not pay unless and until this court directs him to pay any further. So I'm, let the matter be taken up at 2 o'clock, your lordships, and
Yes.
uh,
No, but who is the petitioner here?
he is,
Petitioner and the petitioner,
he's the
Lordship.
petitioner, he's for the husband.
Oh. Okay, we'll take it up at 2.
Much okay.
Next item.
Item 14.
May I please, your lordship, this here was called for your lordship. This is an application for obtaining a Jimma, your lordship, a mobile phone and a PAN card, your lordship. Same was rejected by the learned court below, your lordship. Charge has already been filed, your lordship.
Share achievement. Search sheet laid down, but in the meantime, after filing of the. So far, I've gone for the search sheet matter. So far, search sheet is concerned matter. He stated matter.
We'll take it up in the second half.
Yes.
Yes. Yes, Miss Soren, you have gone through. Ito item given. Goswami, you have
Yes,
seen?
yes, 2 orders have, Lakshmi, kindly take up the record matter.
No, ito.
Record. First, the case, this case matter, dispute PS 447 ended up in FR matter. Thereafter, matter Narazi petition was filed and it was given for further examination, further investigation on matter 24/7/25 matter. Thereafter, it is not clear whether the case has been again, it was end up in search sheet or again. That's it.
So no reflection is there in the
No
order.
reflection. After 24/7 order matter, it was given for further investigation.
On 24?
7 matter lost. Yes, there is a record matter only the matter. Trial court record. First 2 flags matter there. Small flag matter. Small one. This is the order. Last part lost sometimes.
Which order? What is under challenge in this petition?
This matter, Jimma was rejected earlier matter regarding for case matter.
Thereafter?
Thereafter, matter that this is filed, they have filed against that order, they have come to the court. And now in the meantime, matter after filing the.
Okay, heard.
After filing this petition, because.
Heard Miss M.
Please.
P. Soren, learned counsel for the petitioner. Also heard Mr. M. P. Goswami, learned additional public prosecutor. It is submitted at bar that in the GR case number 1973/2022 by order dated 24/7/2025, the Court of Learned Additional Chief Judicial Magistrate has directed further investigation by a different investigating officer, and as regards the status of the further investigation, no report is available before this court. We have to call for the report.
Lodge.
And you will produce.
Will produce matter.
Accordingly, for consideration of the instant criminal petition, the status of further investigation would be required. Hence, let the case diary,
Update my lord, I report.
up-to-date case diary be called for. The learned additional public prosecutor shall produce the case diary. Let a copy of this order be furnished to learned additional public prosecutor.
Pray, my lord, the up-to-date report regarding, up-to-date trial court report, my lord. If any report has been filed there, my lord,
Stop.
my lord,
Further, if
from the registry.
in respect of the seized cash, any report has been filed before the trial court,
In respect of, my lord, further investigation.
as well as in respect of further investigation, same may be called for. The registry shall take steps for calling for the report. List 24th. Let this matter be listed on 24th June.
May I please a lot, sir? Yes. Sorry to make a mention at this. Item 22, which is fixed for hearing today. Can it be taken another day, a short day? We have to do. Because there is a personal difficulty.
You have informed the other side.
Other side, don't know, there is a note, the other side have not yet appeared, or I don't know, because they have earlier refused to accept notice like that. I have an officers for official. So other side. Don't know.
Item 22.
There is also direction for.
Mr. I.A. Hajurika, learned counsel for the. Yes, Mr. Bushu.
But the otherwise is a whole matter. It may be matter given. Item number 22, my lord.
Oh, yes, it is very old matter.
Yes, on a short date, I can also accommodate my. There is also direction for cancellation of the depositions. So that also part of. Yes, my lord. Some testimonies are wherein my lord, that is in Bengali medium, my lord. So one direction was there in one of the order earlier vision order. Just come to the PCM. Next, that on next Tuesday, my lord, possible, my lord.
And Mr. I.A. Hajurika, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty. Also, Mr. K. Basha, learned additional public prosecutor, who submits that considering the old pendency of this matter, a short date may be fixed.
11.
The prayer is allowed. It will go after vacation.
As a loss. Otherwise, I am ready for next week also. You guys can give a date.
What Parini? Okay, 23rd July.
23rd. Yes, on July.
July.
Item 12.
May I
Yes.
please the lordship? Lordship, kindly to. I am summarized the list of order, my lord. Lordship for everything, my lord. I am concerned about the, my lord, interim maintenance, my lord. I am not concerned about the maintenance, my lord. I have already, my lord, paid the maintenance, my lord, as per direction of the honorable court, my lord. My lord, what is the case about, my lord? The case is that, my lord, on 22/2024, my lord, respondent has filed a petition under section 125 Code of Criminal paying for maintenance, my lord, to the court, my lord. At that time, the respondent has not filed any asset and liability. That is important, my lord. Next, that, my lord, on 7/9/2024, case record received back from the learned counsel, both the party are absent. It is to file evidence. If it repeat, asset and license statement on next day. Court has directed to file asset and liability, my lord. Next, my lord, 30/10/2024, petitioner is absent with step present is Hazira for evidence so and so so and so. Next matter 16/5/2008. It was the step opposite party had petition number for another WS page is allowed. It is indicate the opposite they come to the knowledge proceeding of this file against him. Then my lord 26/2024, my lord, the law is that you simultaneously fight the asset and liability before the court, my lord. I file asset and liability on that day, my lord. Petitioner is present, my lord. Opposite party has submitted WS today. The petitioner received copy. Both the party accordingly directed to appear before the court, my lord. On that day, my lord, I filed the asset and liability. On that is important, my lord. 26/2024.
Yes.
This 26/2021. Then, my lord, appeal has been admitted, my lord. The petitioner filed asset and liability on 19/9/12/2024, my lord. Petitioner filed region WS. Petitioner filed asset today along with a copy for the same. Then, my lord, 14 to the opposite party submitted his statement asset and liability. Then, my lord, he again withdraw because he has not filed asset and liability. She did not file the asset and liability, my lord. She filed, my lord, income and expenditure statement, my lord. As per, my lord, the Kusum Sharma case, there is a that has been formatted, my lord, how the asset and liability will be submitted before the court, but she not filed the asset and liability, she filed the, my lord, income and expenditure, my lord. Next, my lord, on 1/4/2025, the court has said, when I showed this thing before the court, shall directed to submit her asset and liability afresh, my lord. And on that day, I filed a 340 petition, my lord, which is not entertained by the court, my lord. Then, my lord, on 9/5/2025, petitioner filed his asset and liability, but she wanted to withdraw for filing the bank statement, the asset and liability statement, petitioner returned to her. Then, my lord, 4/9/2025, after 19 months, my lord, of filing of the case, she filed asset and liability. After 19 months of the case, my lord, she filed asset and liability before the court. And that is important facts, my lord. Because due to that, my lord, from 24/25, case has been, my lord, not proceed, my lord. Then within the 3 months, my lord, the paper has been disposed of, my lord. And interim maintenance have been granted from the date of application, my lord. Now, my lord, your lordship kindly come to the impugn order.
The FC criminal
Yes, my lord.
103 has been finally disposed of.
Not
Is still paying.
And that is why I am submitting. Maintenance is always from the date of application. I am not on that. So far relating to interim maintenance, it is always from the date of order until and unless the honorable court, learned court below has mentioned the special reason why he is granted the interim maintenance from the date of application. That is the judgment of the apex court, many judgment of the apex court. Yes, madam. Judgment. Don't know. Because 125(2) says that interim maintenance should be always granted from the date of order. If there is a special reason has been mentioned,
RPC.
then it shall be granted from the date of application. There, if so, my lord, and if yeah, I don't know. 125(2). Any such allowance for the maintenance or interim maintenance and expenses shall be payable from the date of order. If so ordered from the date of the maintenance in the expenses as the case may be. Or if so ordered, that is important, that has been defined in the Rajnish Sneha case, my lord. What does if so ordered, my lord? Yeah, Rajnish. Okay, move on. Go to the- Trata por ya, depende de nada.
What is the meaning of if so ordered?
Yes, my lord, that has been defined in the Rajnish versus Sneha, my lord. Yeah, no. Page 377, my lord.
Yes.
101B. The second view, then maintenance ought to be awarded from the date of order is on.
Now read from the. Okay. Read from the beginning of the paragraph.
Yes, madam. Para 102
Yes.
from date of order, madam.
Okay.
Have you also got it?
Yes.
Yes, madam. The second view, then maintenance ought to be awarded from the date of order. Order is based on the premise that the general rule is to award maintenance from the date of order, or grant of maintenance from the date of application must be exception. The foundation of this view based on the interpretation 125(2) CRPC, which provide any such allowance or the maintenance or interim maintenance expenses for the proceedings shall be payable from the date of order, or if so ordered, that is, my lord, from the date of application for maintenance or interim expenses proceeding as the case may be. The word if so ordered, my lord, have you also got it?
Yes.
In section have been interpreted to mean that where the court is awarding the maintenance from the date of application, special reason ought to be recorded by you. And if your lordship, special reason has to be my lord, has to be mentioned, my lord. And if your lordship go to this impugn order, hmm? 95, my lord.
Impugn order is that page?
95, my lord. Yeah, 106, 106, my lord. The
Yes.
petitioner is present. Opposite party absent with steps in the petition filed for the opposite party showing the opposite party seriously sick. Prescription issued to the opposite party, Dr. So-and-so, on 1/2/2012 has annexed with the petition with some prescription. Opposite took adjournment on last date. The opposite is not under treatment in the hospital. No recent medical treatment has been produced before the court. On the other, petitioner has stated that opposite party is attending the party's fake illness is false just to defeat the very purpose of the disposal. The case was executed on 22/2024 for interim maintenance. The opposite party is not cooperating with the proposal for maintenance. Therefore, the prayer for a petitioner for interim maintenance had expertise. The petitioner stated that she is unemployed. She depends her mother. She requires monthly expectations, rupees so-and-so, herself so-and-so, her minor daughter. She prayed for interim monthly maintenance, 50,000 for the opposite party who is working as senior consultant on Young Global British so-and-so, that not Naisa is studying in St. Francis School, Gauhati. My lord, from the date of my lord, before divorce and after the divorce also, sorry, while filing of the application, I pay the educational fees to my minor daughter, my lord, regularly, my lord, before filing of the application also, my lord. In that case, opposite party state in his written statement that her net income is 64,000 per month. He has loaned that he is suffering from some sophisticated treatment which is very expensive. As the petitioner has no source of income of his own, therefore she deserves at interim monthly maintenance for her as well as to her minor daughter. When he filed my lord income tax return, there found some income of that particular my lord lady, my lord. I am not on that, my lord. I am purely on law point, my lord, today. Opposite party is directed to pay rupees 10,000 to the petitioner, rupees 8,000 minor data at interim monthly maintenance on the date of filing of the case. Where is reason, my lord? Now, no reason has been recorded. No reason has been recorded, my lord. Why she was allowed to take maintenance, my lord, from the date of application. That is the law, my lord. And my lord, I am giving that judgment. Bina Devi, my lord. Bina Devi has said, my lord. Disha, no?
Where is Bina Devi?
Just read, Your Lordship. That is what has been quoted in Rajneesh versus Neha. Bina Devi is the case law which he just read.
Thus, I given copy.
In paragraph number 102 and 103, Bina Devi has been quoted, Your Lordship.
In 103, Bina Devi.
Yes, good. Yes, Bina Devi.
May I submit, my lord?
Even the ratio of in paragraph 102 is also Bina Devi, Your Lordship.
May I submit? That may I read, my lord, Bina Devi?
Yes.
Yes, my lord. Your lordship, come from the, my lord, second paragraph.
No, where is Bina Devi? You have given a
I have given the copy, my lord. Bina Devi. Dilo na dilo. Huh? Bina Devi.
You have given only Rajneesh versus Neha.
My lord, one Bina Devi.
Yes, Bina Devi.
Yes, ma'am. May I read?
Para?
I'm main reading, my lord. Their paragraph has not been mentioned, my lord. Judgment, my lord. Your lordship, come to the second page of the judgment, my lord.
Yes.
As per the judicial property order passed by the learned session, just concerned for it is not the forum invokes the power of
Where are you reading?
Yes, my lord. From the last paragraph, my lord, of the second page.
So far as.
Yes, that therefore the aforesaid application for it to move by the reasoning court deserve to be rejected is hereby rejected accordingly. So far as the question or ground of revision are concerned, the learned session committed error, thereby passing an order of maintenance from the date of application. I am on the view that is not important, my lord. I am not views as committed no error in the eye of law. Section is very much relevant in this regard. Sub plus 2 provide that maintenance allowance, that is important, my lord, shall be payable from the date of order or if order from the date of application for the maintenance. This is the cantonment judgment in this regard passed by various High Court, Honorable Supreme Court, stating that no doubt maintenance can be made payable from the date of application, but the court is required to record the reason when it award maintenance from the date of application. Otherwise, even if silent so as to date, it will be effective from the date of order for which is not necessary to record reason. If the magistrate should award maintenance from the date of application, not from the date of order, magistrate has to give reason for it. Section 125 to prima facie very much clear in this regard, providing such allowance shall be payable from the date of order. The word or if so order itself provide if maintenance is to be provided from the date of application is to order, that is order the reason have to be recorded. From the aforesaid law, the perusal of impugn order shows the learned session judge has rightly held that order passed by the learned judicial bench, there is no mention as to on what basis maintenance was being awarded from the date of application. I do not find any good to intervene the impugn order passed by the learned session judge, and there is no mention in the order that under which circumstances the order of maintenance shall be enforceable for the date of application of the maintenance. And this asset and liability, my lord, this, my lord, the prescribed format has been maintained, my lord, in the Rajneesh versus Neha, my lord, is only for the interim maintenance, my lord. And she filed the interim asset and liability after 14 months, 19 months, my lord, the filing of the application. And in Rajneesh versus Neha, one thing also said, my lord, that both the parties should file simultaneously, said, so that one party cannot take advantage to the other. But I filed the asset and liability, my mass prior to 14 months. Within 6 months, my lord, and she filed after 19 months, my lord. This is the This is the, my lord, case about this one. And after filing her, my lord, asset and liability, honorable learned court below, within 3 months, the petition has been disposed of. This is the, my lord, factual part of the case, my lord. And if your lordship go to the Rajneesh versus Teha, my lord, your lordship kindly come to the para 65. Lordship kindly come to the page 327 first. Any given 365
Page
368 page, paragraph 65. Para 65, my lord.
yes.
The party claiming maintenance either as spouse as a partner in a civil union, living relation in a common law marriage should be required to file a concise application for interim maintenance with limited pleading, along with affidavit of disclosure of asset and liability before the court concerned as a mandatory requirement. Until and unless, my lord, that my lord, asset and liability will not file accompanying with the, my lord, petition, this petition itself a defective. Although court has allowed them to file after 19 months asset and liability, my lord. On the basis of pleading filed by both the parties, the court would be in a position to make objective assessment of appreciable amount to be awarded towards the maintenance at the interim stage. For this, my lord, interim maintenance, this has been mentioned by the apex court, my lord. Then your lordship come, my lord, 66.
So the requirement is
Yes, ma'am.
that before deciding the question of interim maintenance,
Yes.
assets and liabilities from both the parties should be before the court.
Yes, ma'am.
It was in this case also
Yes.
only after getting assets and liabilities
Yes, ma'am.
from both sides, court passed order. Only it failed to mention special reasons for.
Yes, my lord. Special reasons, my lord, has not been mentioned in the order, my lord. And she filed the affair malady, that is important, after 19 months, my lord. Then, my lord, page 60, para 66. Para 66, your lordship come Kusum Sharma 4. Last but fifth line in Kusum Sharma 4 has been written. Have a look at it. Para 66. Para 66, next 65, next page 66. My lord, your lordship come para 66 last part in Kusum Sharma 4.
Yes.
In Kusum Sharma 4, the court took notice that filing affidavit along with the pleading gave an unfair advantage to the party who filed the affidavit subsequently. In this judgment, it was clarified affidavit must be simultaneously filed both the party. In Kusum Sharma page 42, the court consolidated the format of affidavit in previous judgment directed to same file maintenance proceeding. In my format has been mentioned as already stated. I judgment Annex 1 in Rajneesh versus Neha, my lord. So far, not agricultural people, my lord. Yes, my lord. Then your lordship come to the, my lord, 72.1A. The affidavit of disclosure, asset and liability annex enclosure 1, 2, 3 of this judgment, as may be applicable, shall be filed by the parties in all maintenance proceedings, including the pending proceeding before family court, district court concerned, as the case may be. The applicant making the claim of maintenance will be required to file concise apply accompanied by affidavit of disclosure of asset. That was filed after 19 days, 19 months. Then your lordship come, my lord, 72.6F. 72.8, my lord. Next page, page 370.
Yes.
The pleading made in the application for maintenance and reply filed should be responsible pleading. If false statement and misrepresentation are made, the court may consider initiation of proceeding under section 340 for contempt of court case. Here in the instant case, my lord, she filed in expenditure and my lord income. And in that time, my lord, she filed the income tax return also, my lord. Subsequently, she said in asset and liability, she has no source of income, my lord. Subsequently, since his 10, my lord. And it is concealing the fate of asset and liability. That is why we filed the 340. I am not pressing 340, my lord. This is not the subject matter here, my lord. I am only concerned that misrepresentation means concealing of fact. That fact has been concealed, my lord. Then your lordship come, date of order I have read, my lord. Well, same thing reiterated in this judgment, my lord. In 2023. OVT allies matrix.
Which para?
No, Supreme Court. Para 14, my lord. Nothing is evident from the record or even pointed out by the learned counsel for the appellant at the time of hearing. If it were filed both the party in term of judgment as this case, which was directed to communicate the High Court for further circulation to all judicial officers for awareness for implementation. The case in hand is not isolation even after pronouncement of the aforesaid judgment. This could still come across the number of cases decided the court fixing maintenance either interim or final without being affidavit on record filed by the. Apparently, the order have been failed to take notice the guideline issued by the for invoking grant of maintenance. Comprehensive guidelines were issued pertaining to overlapping jurisdiction among court when concurrent remedies, grant of maintenance under Special Marriage Act 1954-125, the protection of women from domestic violence, Hindu Marriage Act, Hindu adoption, criteria for determining quantum of maintenance that from the maintenance is to be awarded. Enforcement order maintaining fixing payment for as a result, litigation should close at trial level is taken, the court and party forced to litigate. As in the hand, the impugn order passed by the High Court is cryptic. Benefit the reason in our opinion same is liable to be set aside and the matter is liable to be remitted by consideration order accordingly. As the respondent remained unrepresented, the High Court may issue notice on this from the next day. Considering the fact in hand, the other similar coming across before the court, not adhering the guidelines given Rajni's case, we deem it appropriate direct the Secretary General of this court to recirculate the aforesaid judgment not only all judicial officers through High Court concerned but National Judicial Academy, State Academy to be taken during the training program as well order accordingly. So my humble submission before your lordship is that if the learned court below my lord has not mentioned special reasons for maintaining the maintenance or maintaining the interim maintenance, my lord, from the date of order, my lord. Date of application, my lord. So this order has to go, my lord. And I paid the maintenance, my lord, as per direction of the Honorable Court, my lord. From January, I am paying the maintenance regularly before the court, my lord.
You read 109 of Neha.
Yes, my lord. Discussion thus been revealed that divergent view of different High Court, which maintenance must be awarded even judicial decision is conferred upon the grant maintenance either from the date of application from the date of 125 shall be to the appropriate grant maintenance from the date of application in all cases, including in practical working provision related to maintenance. We find there is a significant delay disposal of application interim maintenance for a year, and it would therefore interest of justice fair play maintenance is be awarded. But I am not on that, my lord. I am. You are.
Yes.
I am concerned about the interim maintenance, my lord. Not final. Final, I have to pay from the date of application. I never disputed this point, my lord. There is a specific paragraph in the judgment how the interim maintenance should be granted, my lord, and it is from the date of until and unless special reason has been recorded. And it was reiterated that Bina Devi judgment also, my lord. That is my submission, my lord. I am not saying the maintenance should be granted from the date of order. So far, interim maintenance is concerned, my lord. So far, relating to girl is concerned, my lord, I have paid the educational fees, my lord, and my lord, I am not concerned about the rest. So far, relating to the, my lord, wife, my lord, I pay the maintenance from the date of order, my lord. Okay, sorry, my humble submission before your lordship is there. I should be paid from the date of order because no reason has been recorded. Let the my learned friend has satisfied your lordship where reason has been recorded, my lord. If the reason has not been recorded, it is from the date of order. That is the law. In
Okay, date of order is applicable to interim maintenance
yes,
only.
my lord. Maintenance from the date of application, my lord. I never dispute. That is
Yes.
submission. That is
Yes.
submission, my lord.
Lordships, two submissions for your lordships. Number one, the fact that they have filed this application against an interlocutory order, that itself I am questioning the legality and validity of this particular petition. And I will produce
This petition is under what provision?
lordships, they have filed it under section 482 and calling it a criminal revision petition.
482.
If I'm not mistaken, because the copy which has been served on me, there were several changes in the cause title. So I do not know. If they say it's an appeal under section 19(4) of the Family Courts Act. No, appeal, section 19(4) of the Family Courts Act does not allow you to file any application against an interlocutory order. And read with section 482 of the CRPC 1973. And yet, on top, they're calling it a criminal revision. It should have been filed under 397 in that case, it's not under 482. I will also address your lordships, and I'll also place certain decisions of this honorable court on that particular aspect of the matter. However, since my learned friend has already addressed your lordships on the merits of the matter, I would like to respond appropriately. If I may, your lordship.
Yes.
My learned friend has stated that the order, the impugned order before your lordships does not disclose any reasons as to why the order has been made applicable from the date of the application. Now, he has also relied on section 125 too. I need not stress upon your lordships what exactly 125(2) talks about. Your lordships are already aware of it. If I may just take your lordships to the antecedent facts of the case. A lot of hullabaloo has been tried to be made about the fact that I have filed my assets and liabilities 19 months after I have filed the application. Now, I understand that the learned senior counsel does not visit the family court, so is perhaps not aware of the procedures which are followed. But the assisting counsel certainly visits the family courts on several occasions and should be aware of the fact that the family courts earlier did not insist upon an assets and liabilities at the time when this application was filed in December 2024. There was no procedure that you had to file an assets and liabilities on the same date itself. However, that procedure has now changed. Since January 2026, it has now been mandatory that if you file an application for maintenance, it has to be accompanied by a affidavit of assets and liabilities on that same day itself. That has been made mandatory only from January 2026. My learned friend, your lordship may confirm for my learned friend who is the assisting counsel. Now, on the date that I had filed this application, definitely I did not file the assets and liabilities. No doubt about that. Eventually, I filed it after about 4 months. When we came back from the counseling, we were sent for counseling. After I was sent back from counseling, I immediately filed my assets and liabilities. Now, after filing of my assets and liabilities, they raised an issue regarding the credibility and the correctness of the method and manner in which I had filed the assets and liabilities. Now, your lordships are aware that in the family courts, at times, legal assistance is not permissible inside the courtroom. And that is exactly what happened to the parties. They both were allowed to go into the chambers of the honorable judge, and something transpired. We were told you refile your affidavit of assets and liabilities. And she did not understand anything. She came out, she told her advocate. Advocate did not do anything for several months. Assuming that I am at fault, Your Lordships, assuming that I have made the biggest mistake in my life by not filing my assets and liabilities for 19 months, can that be a ground to be taken for disputing an order which has then been legally passed after considering the assets and liabilities of both the parties, Your Lordships? Now, if I may just point out from the petition filed by my learned friend, if Your Lordships will kindly turn to page 101 of the petition. So I am not saying that I did not, the assets and liabilities filed by me was disputed by them, and it was thereafter that I had to refile it, and that refiling took some time. Thereafter, they also refiled their entire assets and liabilities, by the way, which has not been told before this honorable court. The fact that they also refiled their entire assets and liabilities. It is all in the trial court record, Your Lordships. So why is it that they have not talked about their own assets and liabilities, only about mine? Should it not be a candid disclosure of facts before this Lordship? Now, if I may take Your Lordships to page number 101. Maybe page 99, Your Lordships, before that. Page 99. On 1/4/2025, Your Lordships have got it. That's the first order on page 99.
Yes.
Parties are present, heard the sides. The petitioner may submit her assets and liabilities afresh. Please note, Your Lordships, that it is only on 1/4/2025, after they have raised several objections against me, that I have been given the liberty to file my assets and liabilities afresh. Then fix 9/5/25 for assets and liabilities by petitioner and written evidence of both parties. Last chance. Cross-examination will be taken on the next date. 1 week before the next fixed date, parties will exchange their evidence among themselves. This never happens in the family court, so there's no provision of exchanging affidavits on a date before the date fixed. Anyways, next date, Your Lordships, 9/5/2025. Parties are present. PW1 and PW2 have submitted their written evidence. Petitioner, though, filed her assets and liability statement today, but she wanted to withdraw it for filing up-to-date bank statement. Therefore, the assets and liability statement filed by the petitioner is returned to her. It is also contended before this court that the statement of assets and liability filed by the opposite party is not up-to-date and complete. However, the opposite party is directed to submit supplementary up-to-date assets and liability statement by next date. Fix 17/7 for assets and liabilities and hearing on interim maintenance. So on 9/5/2025, we were still discussing about assets and liabilities of both the parties, Your Lordships, not just me, him as well. Then Your Lordships will kindly take up the next page, page 100. On 9/5/2025, the petitioner, no, this is the same order which they have annexed once again. I apologize. Yeah. 17/7. Your Lordship will go to page 101. That is 17/7. Petitioner is present, opposite party is absent with steps. Fix 4/9/2025 for assets and liabilities plus hearing on interim maintenance. Now, whose assets and liabilities, Your Lordships? His. Next, 4/9, petitioner is present, opposite party is absent with steps. Petitioner has filed her assets and liability statement in the petition filed by the opposite party. It is stated that the opposite party is suffering from throat infection. Therefore, he is unable to appear before this court today. Fix 4/11/2025 for bank statement by opposite party plus hearing on interim maintenance. Last chance. You also will kindly take note. 17/7/49. These two orders are very important, Your Lordship. Then next page, Your Lordship.
Yes.
Page 102. On 4/11, petitioner is present. Opposite party is absent with step. Again, so 3 times he has remained absent. In the petition, it is stated that the opposite party is suffering from high blood pressure and his movement is restricted. The petitioner prays for early hearing on the plea of interim maintenance. Fixing 10/11/25 for hearing on interim maintenance and also hearing of the case. The opposite party is allowed to participate in the hearing online. Even this permission was granted to him, Your Lordships. This is a permission which is not ordinarily granted by family courts. He has been allowed to appear online also, that if you cannot travel, it is perfectly all right. You just appear online before us. Then your lordship, the next page, page 103.
Yes.
10/11/2025. Petitioner is present, opposite party is absent. This is the 5th time that he is absent, your lordships. In the petition filed by the opposite party, it is stated that the opposite party is suffering from high blood pressure and that he is taking a life-threatening medicine Extrom tablet. When I did a Google search, it basically meant that if you were just taking a high BP tablet, your lordships. I do not know about a life-threatening medicine. Fix 3
Medicine can always be life-saving medicine. How it can be life-threatening?
Yes, my lord. Here is a grandstand, my lord.
Anyway,
Lineup 10 is not expert in medical lineup.
correct. Fix 3/12/2025 for bank statement of opposite party and hearing on interim maintenance. Opposite party may appear online on that day. So from 7/7/2025, your lordship, 17/7, from page 101, your lordship will find. From 17th of July 2025, we have now moved to 10th of November 2025, and he has not appeared on a single day. Then we go to 3/12/2025, page 104, your lordships. Your lordships have got it? Page
Yes.
104.
Yes.
If I may read. The petitioner is present, the opposite party is absent with step. Seeing the petition filed by the opposite party, praying exoneration of the appearance of the opposite party on the medical ground. It is stated that the opposite party is suffering from high blood pressure and he is a category of high-risk patient for cardiac arrest. On the other hand, the petitioner has paid for a hearing on her prayer for interim maintenance, which is pending since the date of filing, that is on 22/2024. On the last date, considering the health condition of the opposite party on the basis of the petition filed before this court, today was fixed for hearing on the interim maintenance with the liberty to the opposite party to appear online. As the opposite party has failed to appear online, the petitioner prays for ex parte hearing on her prayer of interim maintenance. On the other hand, the learned advocate for the opposite party has submitted that the opposite party is not in a position to participate in hearing even virtually. Further, it is also submitted that the mother of the opposite party is willing to talk with the petitioner. The learned advocate has prayed for sending the case for mediation. The petitioner does not want mediation. Why? Because we have already come back from mediation on 2 occasions. Once from counseling, once from mediation. The hearing on the prayer for interim maintenance cannot be deferred further. Fixing 5/1/2026 for hearing on the prayer of interim maintenance as last chance. The mother of the opposite party may participate in the hearing representing her son, opposite party. Now, your lordships will kindly note the antecedent reasonings of the orders which are being passed by the Honorable Family Court. And then your lordships will now peruse the impugned order at page 106. Your lordship may kindly read page 106.
Yes.
At 5/1/2026. The petitioner is present, opposite party is absent with step. Seen the petition filed for the opposite party, showing that the opposite party is seriously sick. A prescription issued to the opposite party by Dr. G.C. Nath, dated 1/12/2025, has been annexed with the petition. With the same prescription, the opposite party took adjournment on the last date on 1/12/2025 also, your lordships. So 1 month, the same prescription they are carrying on. If these are not delaying tactics, what are they, your lordships? The opposite party is not under treatment in any hospital. No recent medical document has been produced before this court regarding the health of the opposite party. On the other hand, the petitioner has stated that the opposite party is attending parties and the fact of his illness is false, and just to defeat the very purpose of the disposal of the interim maintenance prayer of the petitioner. This case was instituted on 22/2024. February 2024 to 5/1/2026, your lordships, 2 years. With the prayer for interim maintenance, the opposite party is not cooperating to dispose of the prayer for interim maintenance. What more reasons does my learned friend want? This is reasoning enough.
No.
If we are talking about 125(2), and that an order needs to be precluded by some reasonings, then this is reasoning enough.
No.
Therefore, the prayer of the petitioner. Yes,
You make me understand.
yes, Your Lordship.
These reasons are good reasons for proceeding ex parte.
Yes, Your Lordship.
So he's submitting that
From the
the
date,
reasons for proceeding ex parte, then reason for granting interim order, then also reason for granting interim order from the.
Rajneesh versus Neha, in a minute, Your Lordship. Let me just finish reading this order for Your Lordship's for my satisfaction, Your Lordship. Therefore, the prayer of the petitioner on interim maintenance is heard ex parte. After 7-8 months, Your Lordships, my prayer is now being heard ex parte, and this is the order which the Honorable Court has given. A measly amount of 18,000 rupees for a child who's studying in class 6. A 10,000 rupees maintenance, it does not even cover her school fees, Your Lordships, her tuition fees. Forget about her sports fees, her bus fees. That all I am still paying separately on my own. I'm trying to take money from my parents, from my mother. And what is it that the order says that the arrears be deposited within 4 months from today? So the fight here today is not about anything else, Your Lordships. The fight is about the arrears which have occurred in the matter. That is why they are coming here about the date of inception and the date of order. Because the arrear amounts is now about 2 lakhs rupees. That is all. That is all, Your Lordships. Now, immediately to answer Your Lordship's query, Your Lordship will kindly take up Rajneesh versus Neha.
Yes.
If Your Lordship will kindly turn to page 343, just after the footnotes. The head notes, I'm sorry, just after the head notes. At page 343 are the list. Can you this SSC online price? SSC online.
Just.
Lordships, you got it? Page 343.
Yes. Yes.
The last footnote of this particular page, 48. Lordships, you got it?
Yes.
The Learned Senior Counsel was relying on this particular decision, which has already been overruled by the Honorable Apex Court, Veena Pani Devi. It is a sad day that such judgments are being placed before this Honorable Court. So Your Lordship will kindly remove Veena Devi from Your Lordships, from whatever my learned friend had said. It has been overruled.
Where it has been.
Right there, Your Lordship, 2010 SEC online, Veena Devi versus State of UP overruled.
Overruled in which decision?
Here, Your Lordships, in this is Rajneesh versus Neha. This is Rajneesh versus Neha. 343. They have overruled Veena Pani Devi.
No, that is okay. But that overruled is editor's mentioning. You show the particular paragraph where it has overruled.
So what they have done, Your Lordship, in this entire judgment, they have not specifically given that we are overruling this particular paragraph or that particular paragraph.
But impliedly.
Just show Your Lordship. Your Lordship, can you give me 1 minute? Your Lordship, can you turn to page 375? In this case, actually, Your Lordship, several questions were decided. One was with regard to determining the quantum of maintenance. One was payment of interim maintenance. One was conflicting judgments of overlapping jurisdiction and all of that. Now, number 4 at page 375, this was the question formulated by the Honorable Apex Court.
Yes.
Date from which the maintenance is to be awarded. You also got it, page 375.
Yes.
Paragraph 94. There is no provision in the HMA with respect to the date from which an order of maintenance may be made effective. Similarly, Section 12 of the DV Act does not provide the date from which the maintenance is to be awarded. Section 125(2) CRPC is the only statutory provision which provides that the magistrate may award maintenance either from the date of the order or from the date of the application. Now, after this, there is a detailed discussion at page 376. Starting from A at the top, Your Lordship, page 376, from the date of the application. So now the Honorable Court has considered all those decisions where from the date of application, views have been laid down. Starting from Sushmita Mohanty, then Kanu Charan Jena, then Arun Kumar Nayak, Krishna versus Dharamraj, all of these cases relate to judgments whereby the maintenance has been granted from the date of application. Now, at page 377 is the what my learned friend had read out from the date of order. That is
So
portion B,
those cases.
judgments which are being considered.
Yes.
C, from the date of service of summons. Thereafter, after discussing all of these things, the discussions and directions as pointed out by your lordships in paragraph 109. These are the directions which have been categorically issued,
Yes.
which your lordships have just very rightly pointed out just now. The judgments here and above reveal the divergent views of different high courts on the date from which maintenance must be awarded. Even though a judicial discretion is conferred upon the court to grant maintenance either from the date of application or from the date of order in section 125(2), it would be appropriate to grant maintenance from the date of application in all cases, irrespective of interim or this thing. They have taken away that distinguishing factor, including section 125 CRPC. In the practical working of the provisions relating to maintenance, we find that there is significant delay in disposal of the applications for interim maintenance for years. Here is a case, your lordships. For interim maintenance, I have had to wait for 2 years on some pretext or the other. What no more needs to be said? I'm just going back to that sentence. We find that there is significant delay in disposal of the applications for interim maintenance for years on end. It would therefore be in the interest of justice and fair play that maintenance is awarded from the date of the application. This is the categorical direction of the Honorable Apex Court in paragraph 109. Your lordships will also take up paragraph 113.
Yes, 113.
It's therefore become necessary to issue directions to bring about uniformity and consistency in the orders passed by all courts by directing that maintenance be awarded from the date on which the application was made before the court concerned. The right to claim maintenance must date back to the date of filing the application, since the period during which the maintenance proceedings remained pending is not within the control of the applicant. And this ratio applies to an interim maintenance as well, your lordships. How can there be a conflicting view with regard to interim maintenance or with regular maintenance? That is the only reason why I have not filed any application before the Honorable Family Court or before this court for enhancement of that award, because it is an interim. It is an interim arrangement. The final arrangement is yet to be done. And that is my other leg of argument, your lordships, which I had started initially at the initial phase. I'm also, yes, your lordships.
One clarification which
Yes,
I
your
require.
lordships.
It only says that maintenance should be awarded from the date of application.
Lordships.
Whether it dispenses with the requirement of mentioning special reasons.
No, the special reasons, that's why I was saying, your lordship, that the impugned order, your lordship will read the impugned order. All the reasonings are within the impugned order itself. The learned judge did not require any further reasonings, your lordships. If I may just point out once again, at page 106, what was the finding of the Honorable Family Court judge? The fact that these are the reasons, your lordships, paragraph 1, 2, 3, 4.
No, you answer the query.
Yes, your lordship.
After Rajneesh versus Neha, one proposition of law is clear that irrespective of the provisions regarding grant of interim maintenance in various statutes, it should be granted from the date of application. So that if after the clarification of the law by Rajneesh versus Neha, whether it still requires special reasons, that is my query.
My humble submission, the ruling of 125(2), which my learned friend was relying upon in Bina Pani Devi, has been overruled very categorically.
No, my lord, I have, 103
No, let-
paragraph.
let-
No,
Paragraph 103.
let-
you will get chance to reply.
Yes, my lord.
You will get chance to reply.
Discuss this. Oh, no,
discuss kore se.
What?
You see the head notes now when they have.
Head note-
What is?
head note has
Are
been-
head notes?
Head note has been item.
I do not know how my learned friend is reading the judgments.
My lord,
How do
editor.
we find out the cases which have been relied upon or which have been overruled or which have been cited? That is how we read a judgment. That is how we read a judgment. It is unbelievable.
In judgment, it was not said that we are overruled that judgment.
Lordships, in the head notes, they have overruled several judgments have been overruled by this particular judgment. My learned friend may once again glance at that particular page where 1, 2, 3, 4, 5, 6, 7. 7 cases have been overruled and 1 has been partially limited and 2 have been relied upon. In the entire list of cases, chronological list of cases cited.
No, therefore I am putting query.
Yes, Your Lordship. My
We will not go by the editor's note that editors has put overruled, therefore it is. You have to satisfy this court. The query is
Full submission. Your Lordship, kindly see these are the chronological list of cases cited, and it considering all of these, when the what does Bina Pani Devi say, Your Lordship? Bina Pani Devi very categorically says that 125(2), you have to give specific reasons. You have to record specific reasons. Now that reasoning has been done away with in view of paragraph 109 and 10113, Your Lordships. Where is the confusion here? In view of 109, that reasoning, so Your Lordship will kindly note that the date from which maintenance is to be awarded.
is it your submission as Rajneesh versus Neha says that in all cases the maintenance is to be given from date of application. Therefore, the question of recording a reason also goes.
Naturally, Your Lordship, because once the court has held that all applications have to be given from the date of the all interim orders or all maintenance orders have to be granted from the date of the application, then there is the question of
Rider goes.
itself.
Okay.
That is what my humble submission is. And Bina Pani Devi has been specifically overruled in this regard. You also will find that there is a specific discussion about this whole thing in starting from paragraph 94. How maintenance is being awarded by different courts in different scenarios. That entire discussion starts at paragraph 94.
Yes.
The date from which the maintenance is to be awarded. They have noted that 125(2) is the only provision which gives it, which gives the power to the magistrate to decide whether they want to give from the date of the order or from the date of application. After having dealt with all these cases which were in favor of that, and then dealing with cases which were from the date of order, then they also discussed the cases from the date of service of summons at point number C at page 377 at the bottom, Your Lordships. Because there were some courts who were
Thereafter, they held that
thereafter
in all cases, it will be.
Correction.
No.
Yes.
I want to understand.
Yes, sir.
As after discussing all these scenarios, it held that only one date will be applicable in all cases.
Just
Therefore, the requirement of mentioning reasons also goes. Is it your submission? Okay.
once that the rider itself is taken away, there is no question of giving any reasoning. Even if assuming that my learned friend still says that Bina Devi stands and the fact that although it has been overruled, however, if my learned friend still says that there is a possibility that an order, reasoning should have been given, the order itself is reasoning enough, Your Lordships. That is my, let me say, I call it a backup argument, Your Lordships. My primary argument for Your Lordships is that the reasoning is not required. It is not required.
That may be the submission, that reasoning is not required, but order is not mentioning the reason.
The order itself mentions all the reasons. The order itself mentions all the reasons in case Your Lordship takes the view that an order is required to state all the reasons. The order dated 5/1/2026 talks about all the various reasons why they are granting maintenance from the date from which the application was filed. Especially considering the conduct of the petitioner or appellant or whatever he's calling himself before your lordships. I may also just point out two documents before your lordships. Page 115 of the petition, lordships.
Page
5.
yes.
Actually, I'll take your lordships to page 117 first. 117. Because that is prior in date. 117, your lordships.
Yes.
This is a medical prescription. Heart disease. What is the tablet given? Ultraset. It is tablet given for acidity, your lordships. Pain, abdomen, joint pain, headache, body ache. Anyways, this is a prescription issued to him on 1st of November 2025. You also find the date on the right hand side, top corner. 1 November 2025. Right hand side, top corner. Prescription, wherever the
117.
No. Yes, page 117. Prescription and then date.
Date is 31/1/26.
Lordships,
Page 117.
No, page 117. एक बार check for us. Page 117 तुम्हारे yes, Lordship, I have it as 1st November 2025. Page 117 तुम्हारे क्या है?
1st November.
1st November, your lordships. I apologize if the page numbering is different in your lordship's copy. In my it's from Nazareth Hospital. Maybe it is page 116 in your lordship's copy. I'm not sure.
Yes, Nazareth Hospital 116.
Lordship, can you take the note? Date is 1st of November 2025.
Yes.
Now, your lordship will go to page 115. Annexure 7. At least in my copy, it is Annexure 7. It says Dr. G.C. Nath.
Yes.
You also got it.
Yes.
Is that correct?
Yes.
The date here is 1/12/2025. Now, your lordships will know that on 1st of November 25, he was in Nazareth Hospital in Shillong. On 1st of December 2025, he has certainly traveled to Gauhati to get this certificate from Dr. G.C. Nath on 1st of December. And yet, he has deemed it fit not to appear before the family court. Despite giving him chances to appear virtually as well, he was so unwell that he could not even appear virtually. But he has traveled on 1/12/2025. He has certainly traveled to near Jagannath Iskon Mandir, Jayanagar, Gauhati to get this prescription. Then the next page on 31/1/2026. You also, we are not concerned with this because this is a prescription post the order of the Honorable Family Court. So you also may not be inclined to look into it. But these are the tactics which were being used before the Honorable Family Court to produce different kinds of medical prescriptions that I am being threatened by life by some particular thing. And I reiterate, your lordships, that at the cost of repetition, number one, Rajneesh versus Neha is absolutely clearly the law has been laid down that there is no requirement for any specific reasons to be recorded if the order is being given from the date of the application. And it has been made very clear in paragraph 109 and 113 that there is no question, no second thoughts about it. The order has to be from the date of application, because even that reasoning has been given by the Honorable Apex Court that during such period when the maintenance is being decided, it is not within the control of the applicant.
Yes.
And the fact that she cannot be left destitute during that particular time. So paragraph 109 and 113 are very categorically and very clearly overruling Bina Pani Devi, your lordships. And on the other side, even assuming that my learned friend tries and impresses upon your lordships, because I will not perhaps not get a chance to reply, but even if assuming 1% chance that 125(2) still remains and the order requires some reasoning, the order of 5/1/2026, starting from the first sentence, all the sentences in that order are proper reasonings laid down by the court for granting interim maintenance from the date of the application. Considering the conduct of the petitioner before your lordships, considering the fact that he deemed it fit to not appear before the honorable court deliberately, your lordship. That is my humble submission for your lordships.
We reply.
Yes, my lord. First thing is, my lord, this order is intermediate order, my lord, because interim maintenance has been granted.
Yes.
Interim maintenance has been decided. So, my lord, Tridip Sharma case, I can produce many judgment of the apex court, my lord, where said in module, I think also said that interim maintenance can be challenged under section 482. I am challenging petition under section 482 CRPC.
Is it an appeal under 419? No, under 19.
They say it's an appeal under section 19(4). And the nomenclature is criminal revision. An appeal under section 94.
My lord,
He's calling.
my lord, may I submit, my lord?
Yes.
Yes, my lord. Second thing is that she is harping on that point, my lord. 94. I am first, my submission before the lordship is that I am challenging interim maintenance, not maintenance. And if your lordship go to all these things, discuss about the maintenance. There's a difference between maintenance and interim maintenance, my lord. Let lordship the date from which maintenance to be awarded. Have you lordship got it? Headline 94 page 375. One Tridip Sharma judgment DLT, my lord, intermediate order can be challenged under the 482 also. Even interim order also, intermediate order can be challenged 482, my lord. Have you also got it, my lord? Date from which maintenance is awarded, page 375.
Yes.
My lord. This is for the maintenance. Final maintenance, my lord. I said final maintenance always from the date of application, not from the date of order, my lord. My humble submission before your lordship is that tomorrow, suppose the court has fixed the maintenance 30,000 for both the salary. I submit, my lord. Then I said from the date of application, he can get all these things, my lord. But so far relating to interim maintenance is concerned, law is clear, my lord. I am reading now. There is no provision HM on 12 BB Act, the 125 to statutory provision provide in absence of uniform regime, there is a fast physical maintenance to be awarded, my lord. What has been the maintenance, my lord? Must be awarded. The divergent view taken by the family court are first from the date on which application for maintenance was filed, second, date of granting maintenance, third, the date on which summon of the respondent. Discuss about the maintenance, my lord.
We'll read section 109 once again.
Yes, my lord. Section?
Sorry, para 109.
Yes, my lord. Discussion that the judgment here in divergent view of different high court from the date of maintenance. What maintenance has been used? I am challenging interim maintenance, my lord.
Read completely.
Yes, my lord. Even though a judicial discretion conferred upon the grant of maintenance either from the date of application, date of 125 say it would be appropriate to grant maintenance from the date of application in all cases, including 125 CRPC maintenance, my lord. I am repeatedly said maintenance and interim maintenance are different, my lord. That is my submission, my lord. Interim maintenance and maintenance are different, my lord. In practical working of the provision relating to maintenance, we find that there is a significant delay on disposing the application or interim maintenance for a year. It would be, therefore, in terms of justice play, maintenance should be ordered from the date of application. I am not on my lord maintenance. I am of interim maintenance, my lord. Have a lordship got it, my point? That is my point. Second thing, as he said, many things he has said, see about the doctor's prescription, my lord. There's many judgment, my lord. You cannot question the doctor certificate, my lord. until and unless if you, my lord, challenge the doctor's certificate, whether he asks for medical board, my lord, not any day he asks for medical board, my lord. How can he say? I'm challenging. He is challenging, my lord. He want. না মই তুমি কওঁতে এটা শব্দও কোৱা নাই। My lord, my humble submission before your lordship is that, my lord, it is a fact that 19-month delay took place for filing the asset and liability. This is important. The court, my lord, court has allowed the petition without asset and liability. Where is, my lord? Para 65, I have already read, my lord. May I read, my lord? May I see? Para 65 say it is a mandatory, my lord. Mandatory direction of this stay was not followed. And it is a fact that after filing of, my lord, her asset and liability, within 3 months, the petition has been disposed of, my lord. He want to say, due to my absence in the court, his asset and liability could not file before the court, my lord. Have you lordship got it? He can file asset and liability any day, my lord. And all the doctor's certificate is available. Wrong asset and liability submitted, my lord. Not for as this was assisting counsel. Your lordship, kindly go to the Okalatnama from the very first that there is an assisting counsel to her, my lord.
There is
How
no
can-
Wakalatnama in the family court, your lordships.
My
I
lord,
beg to differ. There is no
she is
Wakalatnama in the
assisting, my
family
lord.
court.
She is assisting, my lord.
We can show
He is, of course, is
in
assisting.
record, his name is recorded.
I'm not on the mind. Her name has been recorded. She said. Her name, informal name has been recorded, my lord. Yes, my lord. My humble submission before your lordship is that, my lord, after filing of asset and liability within 19 days, within 3 months, the matter has been disposed of. And law has been cleared, my lord. 125 swear that you have to mention the reason. You have to mention the reason. Reason has not been mentioned, my lord. I am again reading the order part, my lord.
No, not necessary.
Yes, my lord.
You have already
Yes, my lord.
mentioned
The
that.
order it was not mentioned, my lord.
Okay, heard Mr. N.N.B. Chaudhary. Anything else you want to say?
I want to
Which
see
you have not
his-
said
So-
without repetition.
My lord, in her petition, she said she has no source of income. In page 94, we have annexed the document. She total income has been mentioned, 1,20,000. Page 60 to 94 of the petition.
Heard Mr. N.N.B. Chaudhary, learned senior counsel assisted by Mr. A. K. Kashyap, learned counsel for the petitioner. Also heard Ms. R.S. Chaudhary, learned counsel for the respondent. This it is registered as what?
It is raised.
Criminal petition.
Yes, my lord. I filed the petition under 482, my lord.
So it ought to have been registered as criminal petition,
Yes, my lord.
not as.
That is a curable mistake, my lord. It is a criminal petition should be a revision what has been some with typographical mistake. But your lordship, an application under section 482 criminal procedure code. Have your lordship kindly go to.
Registered as a criminal revision petition.
My lord,
That
your
is a
lordship,
mistake.
that your lordship kindly come to the my lord, my
If
petition.
you have to go by the law, then 19.4 doesn't
Yes,
even
yes,
apply.
ma'am.
And this petition is to be dismissed on that ground itself.
May I submit?
Yes.
Your lordship kindly come to the. An appeal under family can read with section 482 of code of criminal procedure code. My lord.
This revision petition has been registered on filing of an application under section 19 within bracket 4 of the Family Courts Act, read with section 482 of the Code of Criminal Procedure 1973 by the petitioner Ridip Lochan Huzuri, impugning the ex parte order dated 5/1/2026 passed by the learned principal judge, family code number 1, Kamrup Metro at Gauhati, in FC within bracket criminal case number 103/2024, whereby the present petitioner was directed to pay an amount of rupees 10,000 per month to the respondent and rupees 8,000 per month to her minor child as interim maintenance from the date of filing of the application under from the date of filing of what?
He filed, my lord, I filed a petition that interim maintenance shall be paid from the date of order, my lord.
That is not even his ground.
Date of filing of the case. Stop. The facts relevant for consideration of the instant petition, in brief, instant case, in brief, are that the present respondent who is the wife of the present petitioner got married to each other on 16/10/2011 as per Hindu rituals. Stop. And out of the said wedlock, a girl child was born on 10/7/2014. Stop. However, matrimonial discord arose between the parties, and this interim maintenance is filed in 125 odd, and there is a divorce case also.
It's fine.
Yes.
Divorce case is
Yes.
going on.
125 was filed earlier. Divorce is pending.
Divorce is pending.
Which case was filed?
Yeah,
And in the month of
Lordship, I do believe,
The divorce case was filed on 14/2/2023, man.
23.
It was. And
So, I think yes. The divorce was filed by him, Your Lordships.
and the present petitioner had also filed an application under section 27 of the Special Marriage Act 1954 seeking a degree of divorce from the present respondent. Stop. The respondent also filed, the respondent Panki Hajorika filed an application under section 125 of the Code of Criminal Procedure 1973 before the Principal Judge Family Court number 1 Kamrup Metro against the present petitioner seeking maintenance how much maintenance he owes
Implemented as part for my lord.
or seek,
10,000, no?
seeking maintenance
75,000. At page 22, you'll also find my petition has been annexed by them.
H
Page 22, the prayer portions are page
seeking
My income is
maintenance amount of rupees 75,000 per month.
income is 65,000.
75,000 per month. In, from the present petitioner. In the said application under section 125 of Code of Criminal Procedure and a prayer for grant of interim maintenance was also made by the respondent. Prayer for grant of interim maintenance of rupees 50,000 was also made by the respondent. Along with some other relief like cost of the proceeding, etc. By the impugned judgment, by the order impugned in this petition, in this case, the Principal Judge Family Court number 1 Kamrup Metro had disposed of the prayer for interim maintenance by directing the present petitioner to pay an interim maintenance amount of rupees 10,000 to pay maintenance amount of pay the interim maintenance as already described in the foregoing paragraphs of this judgment. Stop. Mr. N.N.B. Chaudhary, learned senior counsel for the petitioner, has submitted that the trial court has erred in granting interim maintenance from the date of filing of the case without mentioning any special reasons for doing so. He submits that the law mandates that in the event interim maintenance is granted from the he submits that law mandates that the interim maintenance shall be granted only from the date of the order, and the only exception is provided in the statute, that is section 125 within bracket 2 of CRPC itself, that when the court may order grant of interim maintenance from the date of application. However, he submits that for doing so, special reasons ought to have been, special reasons are to be recorded in the order itself, which he submits has not been done in the instant case by the trial court. He, in support of his submission, he has cited the rulings in the following rulings of the apex court. Number 1, Rajneesh versus Neha, and another reported in 2021, 2 SCC 324. Number 2, Beena Devi versus State of Uttar Pradesh, reported in 2010 SCC online. No, Beena Devi is not of number 2, Beena Devi versus State of Uttar Pradesh, SCC online ALL 236. He submits that in the judgment of, in the case of Rajneesh versus Neha Devi, though the apex court has clarified that the maintenance is to be awarded from the date of application. However, same is applicable only in case of final maintenance, and the apex court has not specifically mentioned that same ratio is applicable to the in case of interim maintenance also. He submits that in case of interim maintenance, the statutory provisions contained in section 125 clause 2, that is requirement of mentioning reasons, is still a good law. He also submits that in the instant case, the respondent has violated the guidelines of the apex court in not submitting the statement of her assets and liabilities along with the application for maintenance as required, application for maintenance. He submits that the respondent has filed her statement of assets and liabilities after a delay of about 19 months. Delay of 19 months. Any other submission? Yeah.
Delay of 19 months for filing my lord, this is right.
Yes.
And as per my lord, Rajneesh Patel Sharma, it is mandatory to file, it's mandatory requirement file the assets and liability, disclosure of evident liability along with the application mail. Para 65. My lord,
Learned counts.
submit, my lord. I am not pressing Bina Devi, my lord. I have to, my lord, verify it. She said, my lord, but in judgment, I am not finding anything, my lord, about Bina Devi, my lord.
Bina Devi removed.
I don't.
He also submits that this, though there is some error in filing, no, he also submits that even if there is some error in the nomenclature of the instant case as criminal revision, as same has been registered as criminal revision petition. However, as the petitioner has also filed this case under section 482 of Criminal Code of Criminal Procedure 1973, the same is maintainable against an order granting intermediate granting interlocutory interim maintenance. He submits that a petition under section 482 of Code of Criminal Procedure is maintainable in this maintainable against intermediary
Order.
in
My submission, it is an intermediate order because.
intermediate order.
Interim maintenance has been, my lord.
You have referred to some judgment. Intermediate order.
Intermediate order.
Intermediate order.
Intermediate order, interim maintenance has been granted, my lord. That is why.
So, in
Interim
support,
maintenance finally decided, my lord. Interim
in
maintenance.
support of his submission, he has cited you. Give the citation.
One is the Deep Sharma, my lord. Deep Sharma, my lord.
In support of his submission, he has cited following ruling. Stop. He therefore submits that since the impugn order has been passed in violation of the mandatory statutory requirement, same is liable to be quashed. He submits that you are otherwise ready to pay maintenance from date of order.
Date of order, my lord.
He is ready to pay
Already paid, my lord. Date of order.
interim maintenance from the date of order.
It is GLP.
He is also he also submits that the monthly interim maintenance as directed by the court is being regularly paid by the petitioner to the respondent. Stop. On the other hand, Ms. R.S. Chaudhary, the learned counsel for the respondent, has submitted that there is no error in the impugned order passed by the trial court and same needs no interference by this court. She submits that this criminal revision petition is not maintainable on the ground that the order which has been impugned in this case is an interlocutory order. She also submits that the appeal under section 19 within bracket 4 of the Family Courts Act 1987 is not maintainable against an interlocutory order. She further submits that there has been no delay in filing the statement of assets and liabilities by the respondent before the trial court, as it was when the petition under section 125 of the Code of Criminal Procedure was filed before the trial court. At that time, it was not the practice in the family court to seek the to require filing of the statement of assets and liabilities along with the said petition.
One thing I clarify, well, I want to submit. One Pinak data is appearing, my lord, when this application has been filed. Your lordship is 34 and judgment is 2021. Well, Rajnish process there. Is 34 Pinak data one advocate is appearing.
She submits that it was on 17/9/2024 only when the trial court directed for the first time to submit the statement of assets and liabilities. She also submits that the respondent had initially filed the statement of assets and liabilities before the family court. However, when some discrepancies in the same was pointed out by the other side, she was required to file a fresh assets and liabilities, fresh statements of assets and liabilities. After taking permission by the family court. She, however, submits that the petitioner, on the other hand, himself took several adjournments to file the statement of assets and liabilities. Stop. Learned counsel for the petitioner further submits that the apex court has, in the case of Rajneesh versus Neha and another within bracket Supra, has laid to the rest the controversy as to from which date the maintenance or interim maintenance has to be awarded. She submits that the case of Beena Devi versus State of Uttar Pradesh, which is cited by learned counsel for the not sir. Okay. She has submitted that last time case. No, ಈ ಲೈನ್ ತು ಕಾಟಿದ್ಯೋ ತಾರಾಗೊಂದು ಲೈನ್ ತು. She has submitted that in the case of Rajneesh versus Neha, paragraph number 109 as well as 113 of the said judgment the apex court has issued directions to bring about uniformity and consistency in the orders passed by all courts by directing that maintenance be awarded from the date of application, from the date on which the application was made. She submits that the maintenance also includes interim maintenance, and therefore, after clarification of the date of awarding maintenance and interim maintenance by the court, by the apex court, the requirement of assigning any special reasons for awarding maintenance from the date of application as required under section, as prescribed under section 125 clause 2 of the Code of Criminal Procedure is no longer there. She has also relied on the ruling of, in support of her submissions, she has also relied on the ruling of the apex court in the case of Rajneesh versus Neha and another Supra. Any other? Okay. Okay.
Have been laid down, but so far as this particular point is concerned, I think this judgment itself is clear.
One thing I got the judgment, my lord, 1977 4SC351. In this intermediate level. 1977 4SC551 Madhu Limai versus State of Maharashtra. Limai versus State of Maharashtra.
Versus State of
1977
Maharashtra.
SSC 551.
Epilogue citation.
So this will go very badly against him. This is under 397, and I have brought this as an objection that he cannot even file this case under this particular case, under this particular judgment.
I have considered the submissions made by.
My submission is what is the law, apex court law about the day? They have never said they cannot come this
I have
section.
considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both the sides in support of their respective submissions. ... I am reserving the judgment. Heard so and so. Both counsel on Namdeki. Hearing concluded, judgment reserved.
Been absurd proposition, Your Lordships. Today, interim maintenance is here, and you are saying that it should be given from the date of the order. Tomorrow, a permanent maintenance comes, and you say it will give it from that side, from the day of application. It is now, it would be an absurd proposition of law to even consider that specifically in, it is just my, of course, my view, you know.
Well, my submission, I cannot criticize this
Both
part.
of you wait for some time.
Deeply obliged.
Yes, sir, it is. What is the law? I submit before lordship. 77 for SSC. This is not moving matter.
But if I rely on 77.4, then I'm going to rely on the paragraph on the same judgment, which says that an interlocutory application is not maintainable.
I said intermediate application.
Lordships.
And another is TDIP. Sir. I can give the judgment of TDIP Sharma. Our High Court has clarified, my full bench clarified TDIP Sharma, that where the person has gone to kill the then Chief Minister Hiteshwar Soikia.
Okay, give the citations. Give the citations. Yes. Mentioning the paragraphs.
By tomorrow. By tomorrow.
Master blessing.
Thank you very much.
Item 13.
May I please, Your Lordship? Small prayer, Your Lordship. This one, my Jigma for mobile phone and PAN card was rejected by learned trial court below, Your Lordship. Charge sheet has already been filed and the case is pending for evidence since 11/12/2024, Your
What is the case?
Lordship.
What is the case?
It's a NDPS case, Your Lordship. It's arising out of STF case number 625.
DPS for
Recovery of methamphetamine.
one commercial quantity.
Commercial quantity more than 1 kg.
You are on bail or
Bail, Your Lordship.
yes.
Investigation is already
I
completed.
relying on the trial court's order, my lord, quite rejected, my lord, at the stage. It is at page 25, my lord.
This is
This is the criminal revision, my lord.
IA is disposed of, Your Lordship. IO was for condonation of delay, Your Lordship. Section 5, Your Lordship.
paragraph number
Paragraph number 9, my lord,
page.
page 25.
Yes.
Person kindly see, my lord, on perusal of the record, it is found that Poco mobile phone is specifically relied upon by the prosecution to establish communication and conspiracy among the accused persons. The money purse containing PAN card and the seized cash amount were also recovered contemporaneously with the contraband and from part of the seizure list. At this stage of prosecution, evidence release of said articles will prejudice the prosecution case. And accordingly, my lord, the Zimma has been rejected, my lord. After this, my lord, investigation, carrying out the investigation, the search sheet has been laid down, my lord. Now, after filing of this petition, my lord, we came to know the search sheet laid down. Search sheet laid down, the search sheet, it has come, my lord. The search sheet has come, my lord. And may I, the lordship permission, take the
Rashid.
question? At the time of seizure, all were there, and from the telephone there, CDI analysis, my lord, and other investigation, it has been found that they are all in contact with between themselves to carry out this trade. They took it from one person and they were going to sell it to other, my lord. And that has been confirmed by this technical analysis. Here, my lord, I have flag marked because the search sheet is one search sheet, my lord. May I read?
Why you need mobile phone and
Because that is a part of the investigation, because from that phone, my lord, they are maintaining my relationship with the others, my lord, the co-accused, and my lord, carrying out the trade between themselves. That is why it is a part of the. That is why it's a part of the investigation.
Yes, it's in the CDR is already there in the search sheet, Your Lordship.
My lord,
And evidence
during
at the stage of
during
evidence, Your
my lord,
Lordship.
investigation, I have examined the complaint and other available witnesses in the connection with the case and found sufficient evidence against the arrested accused. But during investigation, samples has been drawn in such and such.
and PAN card?
Yes, my PAN card portion, my lord, it is the part. I have collected the FSL report where FSL offended they gave positive test for methamphetamine. Moreover, a CDR report so obtained has revealed that the seized mobile handsets are of arrested accused person, and a call detail report of the accused mobiles forward with their statements and communications between them is found well established as the tower location of their mobile phones before apprehension on the occurrence day found to be same. So, they are using this phone, and from the use of their this mobile handsets, it is a part of the NDPS crime manner, and so far it relates to the crime manner. So it may not be released given Jimma to the accused person's manner, because it is a part of the manner.
Is it a piece of evidence for the prosecution side?
So far,
If it is a material evidence,
because phone is there because the data analysis and also the
what will you prove by phone?
as a phone it could be a part of the primary evidence also, it is.
Lordship, evidence is complete. From the phone, CDR is already recovered, Your Lordship, and same is submitted along with the search sheet.
What is the status of the
It is
Trial.
trial case.
Evidence, it is, next date is 26/5/2026 for evidence, and it is pending since evidence since 2024, your lordship. 11/12/24 was the first day of evidence, your lordship.
Because they are,
Witness has been examined.
because they are person, my lord, why they need the phone, my lord? Because they are so much worried about their phone, my lord.
But
But
being a
they can-
person, this
they-
I had said, I would
They
like
can
to
buy
use your
you,
lordship.
because that phone,
And
my
I'll
lord,
produce
is
this
a
for the
part of
court.
the, my lord, evidence now. my
At the
lord.
time of evidence.
On,
it
my
required-
lord, what it report regarding the analysis, my lord, regarding this petitioner, my lord. Yes, the call, yes, the technical evidence, my lord, the call detail report, accused with mobile numbers corroborates with the statements and communication with other two accused is found well established, and tower location of the mobile phones were before apprehension, the occurrence they found to be the same. So even if the CDR analysis and also the materials that will be available in the my lord phone, that will be, my lord, the piece of the evidence, my lord.
Everything there in the phone has already been extracted, your lordship.
We don't know. We don't know what has been done.
Plus, regarding the iCard and all, that is a different thing, man. But the phone,
What else has been recovered?
recovered by iCard, Aadhaar card, no?
I card only.
Aadhaar card and this phone, my lord.
Aadhaar card or PAN card?
Pen card, your lordship.
Pen
As
card.
Wow, you want your PAN card
Pen
back?
card.
You take back the PAN card.
Yes,
Keep the phone with the
Lordship.
court.
yes.
Heard, Mr. What is your name?
S.A. Hussain, your lordship.
S.A.
Hussain.
S.A. Hussain, learned counsel for the petitioner. Also, Mr. M.P. Goswami, learned additional public prosecutor. This revision petition under section 438/442 of BNSS, read with section 528 of BNSS 2023, has been filed by the petitioners, namely Nersing Basumatari, impugning the order dated 11/9/2025, passed in NDPS case number 379/2024 by the Court of London's Additional Sessions Judge number 5, Kamrup Metro, whereby the prayer for grant of Jimma of one Poco smart mobile phone along with 2 SIM cards and also one brown color leather money purse containing one PAN card. Whose PAN card?
The petitioner's pen card.
Containing petitioner's PAN card and cash amount of rupees 540 were seized in connection with this case was rejected. Learned counsel for the petitioner has submitted that the aforesaid the mobile hand phone of the petitioner along with the along with his leather money purse and one PAN card of and his PAN card was seized on 9/4/2024 when he was arrested in connection with this STFPS case number 6/2024 under section 22C/29 of NDPS Act 1985. He submits that in the petitioner was enlarged on bail in the aforesaid case on 10/7/2025, and thereafter charge sheet was laid against him in the said case. He submits that the trial is pending at the stage of prosecution evidence. Since when it is pending?
Since your lordship, 11/12/2024.
Since long.
Yes.
And he submits that the seized mobile phone, purse, a SIM card, and PAN card along with cash amount of 550 does not have any link with the seized contraband in this case, and as such he submits that the same need not to be retained with the prosecution side. He submits that the CDR analysis has already been done by the prosecution side, and therefore the requirement of mobile phone may not be necessary. He submits that the trial court erred in rejecting the prayer for grant of Jimma mainly on the ground that the articles were recovered contemporaneously along with the contraband and form part of the same seizure list. Hence, he submits that the aforesaid articles may be given in Jimma to the present petitioner. Stop. On the other hand, learned counsel for the petition, learned additional public prosecutor Mr. M.P. Goswami submits that there is no error in the impugned judgment, as the trial court has rightly rejected the prayer for grant of Jimma, as the articles of which Jimma has been sought for by the petitioners were seized contemporaneously along with the contraband. He further submits that the involvement of petitioner in the alleged offense has been established by CDR analysis of the mobile phone of the petitioner. He submits that mobile phone is one of the vital evidence of the prosecution side, and same may be required for the prosecution's case. Hence, he prays not to grant Jimma of mobile phone. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. It appears from record that implication of the present petitioner in the alleged offense is also on the basis of CDR analysis of his mobile phone done by the prosecution side. Hence, the the retention of mobile phone till the trial is concluded, by the prosecution side does have a basis, and accordingly, this court does not find any error in the trial court's order in rejecting the grant of Jimma of the mobile phone to the petitioner. However, as regards the seized money of 500 rupees 540 and seized leather purse as well as PAN card, same may be handed over to the petitioner after preparation of an inventory of the said articles and after taking photographs of the said articles by the who will take photographs.
Will be before the magistrate.
By taking photographs before releasing the same by to the petitioner on furnishing a bond of rupees 25,000. How much is your cost of mobile?
10 to 12,000.
25,000 with an undertaking to produce the aforesaid vehicle materials before the trial court as and when so required. At the time of granting Jimma, a Jimmanama shall also be prepared, and the Jimmanama, inventory and photographs shall be part of the trial court's record and may be used in lieu of evidence if it is so required by the prosecution side. With above observation, this criminal petition is disposed. This criminal revision petition is disposed of.
It is in an evidence stage, not even inquiry. At what stage? Evidence stage.
But it is pending in the evidence stage since long.
Hearing item 20.
The complainant's cognizance is taken, my lordship. In the year, from the year 2024, respondent is not appeared in so many days. Kindly peruse the official notification.
What is the case?
Complaint case. A defamatory article was published in the Assamese newspaper, Proceedings, where cognizance is taken against the petition.
State is not a party.
Complaint case, that's why state is not made.
Heard Miss R. Begum, learned counsel for the petitioner. None has appeared for the respondents. It appears that on earlier several occasions also, no one appeared for the respondents. Though this case is a very old pending case. Stop. Considering the old pendency of the case, this criminal petition is required to be heard at the earliest. Hence, to assess the court, this court inclines to appoint one amicus curiae. Any amicus curiae present in the court? Stop. Accordingly, who is Bijita Sharma? Accordingly, the Srimati Bijita Sharma, whose name appears in the list of amicus curiae. Oh no, Bijita Sharma is for division bench. He was appointed yesterday also.
Oh, he is in that case.
Barnita Chaudhary. You suggested him. Her name is there. Legal aid counsel list. Putul. No. Papuri Priya Das' name is not there in. In this case, we will be appointing amicus curiae. Srimati who is Barnita Chaudhary?
Can be given.
Srimati Barnita Chaudhary is appointed as amicus curiae in this case. The petitioner is directed to furnish copies of criminal petition to the newly appointed amicus curiae. The registry is directed to reflect the name of Miss Barnita Chaudhary as amicus curiae for respondent number for the respondent in this case in the cause list henceforth. List this matter again 4th of August. The interim order shall continue till next day.
May I please have sir?
Yes.
The revision is directed against the judgment and order of conviction of the petitioner.
Conviction.
Yes, my lord. The petitioner has been convicted under section 341 and 326, my lord. Under 341, he has been convicted for 1 month and a fine of 500 in default simple reason imprisonment for 1 month, my lord. And under section 326, he has been convicted for 5 months, my lord, and a fine of 2,000 in default simple SI for 5 days, my lord. What happened in this case, my lord? The informant is the father of the injured, my lord. It's alleged that on 12/12/2021 at about 5 p.m. while the injured was coming in his Tata Magic vehicle carrying paddies from his paddy field, the accusee confronted injured right in front of his house, my lord. There is a confrontation between these two persons, and then he gave a down blow to the injured, my lord. That's the allegation in the FIR, my lord. The FIR was lost on 14/12/2021, my lord, and then subsequently he was accused was arrested, and he was in custody for more than 2 months, my lord, during investigation, my lord. He was arrested on 17/12/2021. Then subsequently he was released on bail on 5/2/2012, my lord. As per the FIR, there are
So you were sentenced for 5 months.
only 5 months, my lord.
So 3 months are remaining.
Or 3 months are to be left, my lord, to serve. If your lordship, though there are certain grounds for his acquittal, but if your lordship want that, I will not argue on the elaborately on the evidence, my lord. If your lordship considers his sentence only because he is not if the conviction remains, then nothing will harm him, my lord, because he is not a service holder, my lord. And I do not have any contact with the client also as of now, my lord. If that is his sentence is considered that if already the sentence he has served, if it is reduced to that, then I will not argue on any other point. Reduced to 2 months. He was in custody for more than 2 months. Exactly 2 months, one day, my lord.
Otherwise, very minimum punishment were given. That is.
The injury has not been proved, my lord. Because initially he was taken to the Dangori PSC, then thereafter he was taken to the Tinsukia Civil Hospital. But none of the doctors of the Dangori PS and the Tinsukia Civil Hospital were examining, my lord. Subsequently, he on his own went to the Assam Medical College. A doctor of Assam Medical College was examined in this case only, my lord. But he was treated as per the evidence, he was treated only at Tinsukia Hospital, my lord. But no doctor from the Tinsukia Hospital was examined in this case, my lord. The alleged dhow was seized by police, but that was also produced in the court only. And there are alleged two eyewitnesses in the offense occurrence. They have seen the occurrence as per the version of the informant and injured, my lord. But one of the PW2 and PW3 are the alleged eyewitnesses, my lord. But PW2 has not spoken anything about the presence of PW3 at the place of occurrence, my lord. The injured has stated only the presence of one PW, my lord. And that PW has stated he has not seen the incident, my lord.
Who?
The alleged eyewitness, my lord.
Who is that?
PW2, my lord. Rituras Bora. PW1 is the informant. He is the father of the injured because he has not seen that incident. PW2 may read, no?
Yes. You make your submission in brief, then we will consider what to do.
Okay. Before recording the testimony of PW2, the PW2 was a minor at the time of the incident, my lord. He was studying in class 9 at the time. Before recording the testimony of PW2, I have put some questions to him and ascertain whether he is capable of understanding the question put to him and answer properly. And on being satisfied that he was attained the sufficient maturity and understanding the questions put to him and answer accordingly, his deposition is recorded, my lord. ডকত থকা আসামিক মই চিনি পাওঁ, বছৰীয়া গকুল সোণোৱালক চিনি পাওঁ। 21 চনৰ 2011 চনৰ ডিচেম্বৰ মাহত এদিন সন্ধিয়া 5মান বজাত মই আৰু মোৰ মামা গকুল সোণোৱাল is the injured, my lord. ধান লৈ মেজিক গাড়ীত ঘৰলৈ আহি থকা অৱস্থাত ককা দেউতাৰ নঙলামুখ পাওঁতে কিয় দীপাৰ মৰা নাই বুলি আছামী পুষ্পকুমাৰে সোধাত মামাই দীপাৰ দিয়া আছে।
But this is a criminal revision petition.
Yes.
We have to, if we don't find any error in the appellate court judgment,
There are some errors in it. Because,
in the appellate court judgment,
yes, my
we
lord.
cannot go into appreciation of evidence
Yes, that I
at the
understand.
revisional stage.
Because
That
why he was
he-
not given the benefit of the the provisions of 360 CRPC, that was also not been recorded, my lord, in the judgment, my lord. Because the punishment is only for 5 months, that has to be recorded, my lord.
it was not recorded.
Yes, my lord. No explanation was given, my lord.
It is there.
That is.
Sir, sir,
Sir?
here. The last question is.
That one thumb has been,
Sir?
There before the order. There is a paragraph.
Oh, there is a paragraph, my lord.
no, you show a authority that in exercise of revisional powers, without interfering in the conviction, we can modify the sentence.
That I'll.
If you give a, then we may perhaps lower the sentence of imprisonment, keeping the fine intact.
That I'll give, my lord. Your lordship will kindly fix it on Tuesday. I'll bring the.
Yes.
Yeah, there are several judgments of Supreme Court also, so I'll give.
Okay. Heard Mr. R. Shekhar.
Let it be parted.
Heard Mr. R. Shekhar, learned counsel for the petitioner. Also heard Mr. M.P. Goswami, learned additional public prosecutor. Hearing remain inconclusive. Let this matter be listed Tuesday, 9th of
Yes.
9th of June as a part heard matter, as first hearing item.
Item 24.
Yes.
Take some other day because request some hearing lordship. Against the order of maintenance lordship, husband was directed to pay.
Is for the other side.
Shown lordship.
Heard Ms. P. Bhattacharjee, learned counsel for the petitioner. None has appeared. P. Bhattacharya, learned counsel for the appellant.
I'm for appearing.
Also heard Mr.
I'm for
M. Hussain, appearing for the respondent. We will, due to paucity of time, we'll adjourn this matter. We don't have much time left.
If possible, 18 lordship, 18 June.
We'll fix a short date.
Yes, 18 June if possible.
Due to paucity of time, this matter could not be taken up for hearing. 18. Let this matter be listed on 18 June.
Obliged.
Most of it.
Item 25.
If, yes, what is this?
This may also is not going to be concluded today. So you must may have it some other day. If it's not.
What is this?
Lordship, I have seeking quashing of a criminal proceedings, lordship.
Is there any stay?
Stay is
There
here.
is a stay.
We'll fix it some other day because we don't have much time. Heard Mr. S. A. Riaz,
These are
GZ, heard Mr. GZ Ahmed, learned counsel for the petitioner. Also heard Mr. J.C. Bor, Miss S.H. Bora, learned additional public prosecutor, as well as Mr. J.C. Bora, learned counsel for respondent number 2 and 3. Staff, this matter could not be taken up for hearing today due to paucity of time. Hence, let this be listed again. 23rd July.
Interim is until further orders.
The interim order shall continue till next date.
Already there
in the month of June, last part, my company.
No, June we are very tight.
Yes.
Let it be on July.
only there is an order until further orders. Earlier occasion from this honorable court.
Then
interim-
this is not required.
Not required. On the last occasion, it was passed inadvertently. Not
Yes.
required.
Interim or to na lage.
What's up?